It's time for Friday Night Live. This week has been so legally busy. Some of it's going to next week. We can't get to all of it tonight. So I will tell you a little bit about what we're going to get to this week, what we're going to get to hopefully on Tuesday. Y'all, it's been a week in law. So, in our quick roundup, we're going to get to Jen Shah's trial and the Kanye Kim divorce. I touched on how I felt about Kanye's new music video in a tweet or a series of tweets on Twitter and in an article where I gave comment to the LA Times. So, that is living over on Twitter. If you don't use Twitter, I will try to link that on the channel in the community tab after the stream tonight if you want to see kind of what my thoughts were. I'll touch on that a little bit, but not too much because we really do try to be kind in the chat, not diagnose people, not talk negatively about mental health. And some of the things going on with Kanye are very troubling, and it's very difficult to discuss in a neutral fashion, but we will do our best here as law nerds. And then we are getting into the Cardi B Tasha K request for injunction. It's very interesting. I'm not surprised. We knew this was coming. The hearing is coming up in April, so I'm not surprised that we got these motions. And then the H3 anti-Slapp 800-page of it all. There's a lot of information in this anti-Slapp. There are multiple really interesting declarations, one from Ethan Klein. We've look, the fact that a court is going to have to figure out who Keemstar and Trisha Paytas are to be able to parse this case is fascinating to me, and I'm not over it. So we have so much to get into. Replay crew, love you the most. It will be linked down below, all of the timestamps at the end of the stream so that you can hop to the topics that you want to get to. We're going to talk about what a week it's been. I am drinking water to match my new shoes. Oh, we're going to roll the intro. We have a special guest after the intro. So, oh, you've blown the surprise. We're rolling the intro. It's not a surprise anymore. We're rolling the intro. Come on. Come on. We're going to roll the intro. Say hi to the chat. We're going to roll the intro. Can you say let's roll the intro? Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. Wait, why am I turning into Tommy Innit?
Because you curse.
I do curse sometimes. They can't see you. Let me scoot over. You're gonna have to come right over here if you want to say hi. G had hat day at school today, and he wanted to show you all his beloved fedora.
And the fedora is good. I can't say it's like Triangle Boy pet. Can't say it. Can't say it.
Yeah, you can.
There's a TV show called Phantom Firm on Disney Plus.
Mm-hmm.
And where there's two birds, Pet Platypus is a secret agent and wears a fedora.
So it's like Perry the Platypus's
fedora. And we made a joke about putting it on and then putting
Agent G.
Yeah, and then other stuff.
Well, get the fedora back on. We've had a busy week. There were lots of theme days at school this week for reading week.
I want to go to school to go to the book fair.
We tried to go to the book fair this week. So this week was read across.
It was delayed yesterday.
No, it wasn't delayed. Do you want me to tell them what happened?
It was delayed.
It wasn't delayed.
Yes,
we had the wrong day. We were a week early.
It was delayed.
Wait, it was delayed?
Yeah.
We weren't wrong. We just didn't know. We don't always check our school emails. And the book fair was supposed to be on Thursday. So we showed up on Thursday, and the book fair is next week.
That's not. It ends next week.
The book fair. We will make it to the book fair at some point. I promise. The book fair is the highlight of the year, I think.
Everybody made us hit 10 million.
We haven't hit 10 million subscribers yet, Money. We did hit 100,000, and look, we're almost at 200,000. So, do you want to tell people to like and subscribe, and then we
Like
can
and
go?
subscribe and I'll release a YouTube channel.
You are not releasing a YouTube channel.
Yes, I am. You never let me release it. I say it out loud.
You're gonna manifest it by saying it out loud.
Yeah.
Okay. Love you, hon. Bye, buddy. Don't worry about it. We got to get back to streaming. We got a lot to talk about, darling. Oh, we're back.
Bye. Bye.
Yep. Bye, honey. So we tried to go to the book fair on Thursday. We showed up. The parking lot was empty, and we were like, oh, this isn't going to go well. The book fair parking lot is empty. And we walked in, and there was another sign that the book fair is next Thursday. So Scholastic Book Fair is coming up next Thursday. But yes, they still make the Scholastic leaflets. He has gone through and circled the books that he wants at the book fair. The book fair is such an incredible thing. He really just enjoys it. So he is also trying to hold me hostage and saying like and subscribe, and I will start a YouTube channel. All he wants in life is his own YouTube channel, and we're just not quite there yet on letting him free on the internet, but we're letting him start to record all of his things. So he loves it. One of our favorite YouTube channels as a family is Odd Ones Out, and so I'm encouraging him to maybe start a drawing channel where he can voice over things, and then his face is not on the internet, and maybe he has a little more time to be a child. But he loves YouTube, and it's hard for me to be like, no, we can't with YouTube, because he loves YouTube. So I'm very, very excited about book fair. We missed it last year because of, the last 2 years because of the panini. So it'll be nice to be back. It's our first book fair at his new school since we've moved to Tennessee because of the panini. So very, very excited. So yes, maybe future booktube. He loves books. We had a members only where we read one of the books that he brought home from school that was quite a lot of fun. That book is still on my Amazon list. My hair is down for the first time in a couple weeks, and it's so it's so long, y'all. I can't there. It's gotten out of control, the hair, but we love it. All right. We should get into our weekly roundup because it's time. We need to do a roundup. A lot happened this week, and we're going to start our weekly roundup on Instagram because that's what I want to do. That's what I'm going to do. So that's what I'm going to do. Quick. Did I roll the wrong one? Yes. Yes, I did roll the wrong one. All right, we're going to start the first one on Instagram because that's where we need to start with weekly roundup and quick bits, because what's been going on over on the gram, we need to discuss. Emily, is your screen share ready? No. We're professionals here, people. Why would I be ready to share my screen when I know that that's literally the entire thing that I do here on the interwebs? All right, let's talk about Britney. Wait, there are posts missing. Oh, nope, there sure aren't. All right. First of all, Britney has talked about her shoes. I have lots of shoes. These are my favorites. Stop telling me to buy new shoes. I think it's a direct communication to Heather McDonald, who has regularly stated on the Instagram and on the YouTube, what's going on with the brown shoes? Why always the brown shoes? It's always the same pair of brown shoes. So I think that is a shout out from Britney to Heather McDonald saying, no, I love my shoes. I love my shoes. We're just. But what else has been going on is that Britney has been referring to Sam Asghari as her husband. Did they get married in French Polynesia? Wait, I didn't mean to do that. Hey, Sam Asghari. I didn't mean to click to the other Instagram. She's been referring to Sam as her husband in a number of Instagram posts. Did they get married while they were in French Polynesia over Sam's 28th birthday? Or not. I'm so curious. I want to know. I'm just wondering if they eloped because there's this really cute picture of them for Sam's birthday. They look lovely. Like I could see Brittany. I mean, we all saw her wedding pictures to Jason Alexander. She was with her hair up in a sweatshirt. I think they look dashing. I think they could have gotten married. I think they could have gotten married on his birthday. Um, I love that she's like, I want a family. I want it all. She talked about that in her court hearing. I want it all. I want the real deal. Um, so maybe Brittany got married. I don't know. I haven't seen a marriage license. If they had a marriage license pulled, they would have to do that at some point. I know that there was court filings and conversations about a prenup. Maybe they've just decided that they are married and they are not legally married. They have made that commitment to one another. Who knows? But Brittany is now calling Sam Asghari her husband. And the reason I say he's 28 is because he said that he was 28 on his Instagram. Hold on, I'll pull that one up on his Instagram because his Instagram said 28 and counting. Most of you think I'm 49, but you're wrong. I don't know anyone who thinks Sam is 49. But yep. So I just wonder if they have decided that they are married, that they have made that commitment to one another, if they have had a ceremony that is not a legally binding one yet, and that they are still working out the prenup. So maybe that's what happened. And that's why she's like, this is my husband. We got married on a beach. They didn't do a marriage license. They didn't do the papers and got married, and they can figure out the rest of it legally later. And then if she wants to get married, at a courthouse or by her lawyer or something, she can. I have married people. I have married multiple people. There was a period, well, I performed the wedding ceremony for my brother and sister-in-law, and people were like, "What are you doing?" I'm like, "Oh, I'm marrying my brother." I'm like, "Wait, how do you express that properly?" I'm the officiant at my brother's wedding, and friends as well. So I have performed multiple wedding ceremonies. It was lots and lots of fun to be included in somebody's big day that way. Dr. Riley, you're making me laugh in the chat. So I think she is I don't know. I think they could have had a marriage type commitment ceremony where they had a marriage on the beach and they just are ready to move on. And I think that he has put up with so much with the conservatorship and the control of her family. I just hope they are definitely traveling more, and I hope that I don't know. I hope that they get to be themselves, they get to be happy, and they get to live their life and have everything that they both want. Because I feel like Brittany is getting to start her life for the first time at 40, and that has to be a very weird sensation. At 40, I'm like, "Can I go to bed by 10 get a better moisturizer?" Like, I'm tired. A lot of life has happened, but I feel like for Brittany, she hasn't gotten a lot of life to happen. She has been, controlled and you know, basically has gotten to work and that's it. So I feel for her. All right. Let us let us move on. What is next on my list? Oh, I'm gonna look at the poll first. So the poll said, what are you guys most looking forward to? Kardashian West Divorce, 37%, Klein versus Cav 27%, Cardi B, Tasha K, 21%, and Jen Shah trial updates, 12%. So since that is the least favored, let's go through that real quick. Let's get zoom right through that. Jen Shah's trial's gotten delayed till at least July 11th. And yes, I typoed July 11th to July 1st on Twitter, but Twitter doesn't let me edit shit. So when I fat fingered just one instead of two ones, it happened. And then I don't want to delete it because it's like, well, Twitter. So I'm going to pull up the order and we're going to talk about the scheduling order. We'll also talk a little bit about this motion from ABC because it's fascinating. And then we're going to scoot right on. So this is the court's order. You guys know when people are talking about legal anywhere on the internet, it's always so helpful when they show you what they're taking that information from. And then you just know it's the official information. I hate it when outlets and individuals don't share that. It's like court documents say, "Show me, show me." So this is from that emergency meeting on March 1st. A conference has been held today with counsel for all parties present and defense counsel having waived her appearance. It's hereby ordered that defendant shall file a response to the pending motion to quash a subpoena by March 4th. Oh, those should be in today. Oh, maybe the mods are like, no, don't derail yourself. It wasn't up earlier when I checked Pacer, but maybe we'll sneak a peek and see if it's populated yet on Pacer. The reply to that motion is due March 11th. Defendant shall respond to the ABC motion to quash by March 8th. By March 11th, the reply is due March 18th. The final pretrial conference is adjourned till June 27th, which means there will be another pretrial conference on June 27th. The trial is adjourned until July 11th, meaning it's being put over until July 11th. However, the parties should be aware that although the court is submitting the jury request for the trial to begin on July 11th, the trial date may be rescheduled by the court's ad hoc committee on the resumption of jury trials to another date in the third quarter of 2022. The court will notify the parties as soon as the third quarter trial calendar has been established for trials at the Southern District of New York Federal Courthouse. At the request of the government and the defendant taking no position, the time is excluded from calculation under the Speedy Trial Act from today until July 11th. This is stemming mostly from the issues that the panini has caused backing up criminal trials. I've shared this on social media, so if you follow me there at the Emily D. Baker on the Instas and the Twitters, I shared the background of this, and we talked about the background of this a bit on Tuesday as well. The ad hoc committee is scheduling out the trial dates. There were 3 trials scheduled for March 22nd. It seems that the court has been made aware that at least one of those trials that was preceding Jen's, coming before hers, taking priority over hers, was going to start on the 22nd for certain. And with federal trials, you generally know the defendant's like, we're doing this, and the government has no option but to be ready. And since they indict, they're generally ready before the case even begins. So when the government's like, we doing this, then you know that the case is ready to go. So this case still has more going on in the pretrial motions with all of these freaking subpoenas. So this can't come as a surprise to the defense attorney that there's all these motions to quash. I don't think they're going to get what I think they're going to get from these subpoenas. I'm just like, boo, I don't think you're going to get what you're going to get. I don't. For those of you asking, does this mean I will be heading to Arkansas? Yes. Yes, I will. So that is my intention. Unless something goes off the rails, it is my intention to just go to the Duggar sentencing and see what happens. I'm still waiting for those sentencing memoranda. Speaking of sentencing memoranda, we have to talk about one other thing in the Shah case as I pull it up to see if anything's populated since when I checked this morning. Stuart Smith was supposed to be sentenced today. Here's the thing. I did not see any single minute order putting the sentencing over. Other defendants who have had their sentencings put over until April and June have minute orders reflecting that those have been postponed until those future dates. That has not happened with Stuart Smith. There is not a minute order anywhere showing that sentencing was put over. Interestingly enough, let me pull, I'm just going to show you. We're all going to look at Pacer together. Oh, damn it. I put it in the wrong order. Hold on. We're not doing it that way. Ugh, we'll have to scroll forever. All right. We're going to scroll together as I chat. I also didn't see sentencing memoranda. Yep, there they are. 4 y'all. 4 we'll get there in a minute. With that, you will see that there are a number of documents that have been filed these were deficient, but there have been a few things filed under seal, but not many recently. You see the, amended order, and you will see in here when the court seals something, they say it's been sealed, so we know that something was placed in the vault. There has not been anything sealed, and there's not been any sentencing memorandum. So when there are sentencing submissions, it's very, very clear. I'm going to try to make this bigger so y'all can see it. When there are sentencing submissions, it's very, very clear that sentencing submissions have been made. There were no sentencing submissions on this docket or recent documents placed under seal as to Stuart Smith. So at this point, it is either that it got put over and it didn't make a minute order, which is an odd occurrence. Almost everything should be on the record. He was sentenced and it happened under seal, which is odd because all of the other defendants that have been sentenced, it's been publicly known. And with all the other defendants that have been sentenced, or that haven't been sentenced yet, it's been put over for future sentencing. So that's all been in order, but there is nothing in here that indicates that that sentencing went over or that that sentencing happened, and there's no sentencing memorandums. So what happened with Stuart Smith, I don't yet know, but I am looking into it. The Bravo Docket mentioned it today on Instagram too. I love their Instagram account. If you like keeping up with the legal Bravo of it all, the Bravo Docket are two fantastic lawyers who were in The Housewife and The Shah Shocker, who keep up to date on this and post that on, I believe they're on Twitter too, but I always see them on Instagram. It's the platform I tend to prefer. I love talking to y'all on Twitter, but I don't spend a ton of time on Twitter other than popping in and talking to y'all. So let's see. The memorandum in opposition has been filed by Jen Shah. The transcript of the proceedings are going to be available. The redaction requests are going to go through. Notice of filing the official transcript adds to Jen Shah to allow them to make redaction requests is there. So I will pull up the memorandum in opposition in just a second. There was one other thing I wanted to pull up. I think. Oh yeah, I wanted to pull up the ABC order. I wanted to pull up the ABC memo. I'm fascinated to see how we're getting around all of the legal privileges when Jen Shah's attorneys were like, "Give us all your shit." No. And we haven't done a thorough breakdown of those, and maybe we will just do like a podcast episode condensing all of this together and do kind of a let me know in the chat or in the comments brain in the comments down below if it would be helpful to do like a case brief of where we're at with the Shaw case, just a case brief of this is what's going on with these subpoenas, this is where we are getting ready for trial, these are the rulings the court has made, these are the items that are still open. If that kind of a shorter case brief would be helpful for this case, I will do that. I just want to quickly scroll through what the preliminary statement. Well, no, I want to scoot through what is being asked for. I know we covered this at the end of the day on Tuesday, but for those of you that did not stick around till almost hour 3 on Tuesday, I understand. Let's scoot through this. This is the subpoena from Jen Shah asking ABC for all of their stuff. They're saying that defendant cannot satisfy their burden to overcome journalistic privilege or journalist privilege. A party demanding production of non-confidential information obtained through news gathering bears a heavy burden to overcome the journalist privilege. The burden shifts to Jen Shah's lawyers to prove why they get it. Defendant must show the materials are at issue are at sentences that the materials at issue are of likely relevance to a significant issue in the case and are not reasonably obtained through other available sources. So the subpoena seeking confidential information, they're arguing meets an even higher burden. So let's look at this subpoena real quick because the subpoena for quite a lot of information. I should scroll well, it's not on camera because it just keeps parsing out because it's, 23 pages long. Where is this attached subpoena? Why am I not seeing it? Urgh. There it is. There's the items asked for. The subpoena asked for all footage made or used in conjunction with the program, including raw footage and unaired footage regarding the Hulu housewife and the Shah. All documents and communications between ABC News and any member of the prosecution team, identification of all members of the prosecution team who provided information to ABC News in connection with the program, all releases, waivers, or other documentation provided to any individual who appeared on the program, all video footage concerning defendant Jen Shah filmed in preparation for the program, all documents and communications concerning all interviews taken for the program, including unpublished journalistic work. Unpublished journalistic work product. No. Such as interviewer notes and internal memoranda, all documents and communications between ABC News and any employee or representative of four specified companies concerning the program, whether or not those communications refer to defendant. That is way overbroad, and it's going to be a huge mess. So Jen Shah's attorneys have responded not to this motion to quash, but to all the defendant's attorneys saying, what are you even doing? Also covered on Tuesday, where her attorneys are seeking confidential attorney work product of the co-defendants. What? You can Oh my God, this thing is 97 pages long. Okay, part of it's a transcript. We're not doing that tonight. Let's take a quick peek at it. And let's look at what these headings are, and then we're gonna scoot. We've got a lot. Look, there is so much legal to cover tonight. We can't do it all. This will have to be broken down over the weekend, Tuesday, and then I will probably do a case brief. The subpoena satisfies the Rule 17C. The materials sought are relevant, admissible, and specific. No, all your communications is not specific. How do you argue that with a straight face? They're not otherwise procurable because you're not entitled to them. They're not protected by privilege. Oh, the hell they aren't. We're just going through quickly. Most of this is an attached transcript. On February 8th, the defense served subpoenas on attorneys for 8 individuals, each of whom are cooperating witnesses in the above captioned matter. By cooperating witness, do you know what they mean? The co-defendants who've already pled. All of the co-defendants that are going to testify against Jen Shah. Them. It means them. As written, the subpoenas requested 3 categories of documents. All documents and communication between counsel and any member of the U.S. Attorney's Office in this matter. No. All documents and communications between counsel and any law enforcement agent concerning this matter. No. I can't believe they're arguing this. Like, what? Somebody needs to explain to me how you're arguing this with a straight face. All attorney notes or other documents prepared by counsel for each proffer session attended by counsel's client in connection with this matter. Do you know what that means? Here's what that means. All attorney notes are confidential attorney work product. Full fucking stop. In connection with the proffer is her trying to get at what the co-defendants said to the government, and some of that the government will have to turn over to Jen Shah with regard to those witnesses. The fact that they've wasted money and time serving these subpoenas that ultimately delayed their trial because the court's like, look, we got a bunch of shit to do anyway, is so bizarre to me. Like, why, girl? Why? What do you need? The government's going to give you this. You can never get attorney notes. Why would you do this? Like, what? I don't understand the thought process here. I just don't. Because it's so fucking basic. This isn't like look, with Josh Duggar's defense attorneys, I have given a lot of grace for the kind of out there arguments they've made about the appointments clause because they were stretching, man, but they weren't stretching in a direction where they actually cannot go. They were look, the appointments clause argument was It was out. It was on a limb. It was throwing spaghetti at the wall and see what sticks. But at least you can make the argument that somebody was improperly appointed. It's an argument to make. But this isn't even an argument you can make because it's privileged. The fuckery. The fuckery. The fuckery. Okay. Regarding category 3, yes, please. Let's talk about Bruno here. Regarding category 3, defense counsel made clear that the subpoena does not seek any attorney opinions or oppression, but only seeks notes that were transcripts of statements made by either the government or the witness during the proper sessions. Order the transcripts then. Order the transcripts then, not the notes. Okay. The issue before this court is whether to grant the joint movement's motion to quash subpoenas which only seek, okay. They only seek documents and communications between counsel and the U.S. Attorney's Office concerning this matter regarding substantive factual discussions, including any revisions to the plea allocution. The government can turn that over to you. Well, the finalized one, not the conversations, because that's going to be that's not going to happen. Documents and communications between counsel and law enforcement regarding substantive factual discussions, including revisions to the plea allocution. That's not what the subpoena says, though. You don't get to rewrite the subpoena in your response. That were transcripts of statements made by the government or witnesses during the proffer. You can get the transcript. You're not going to get the notes. This is not happening. See what some of their other, we know the factual background. The subpoena satisfies the requirements. We're not even going to get into the Rule 17 requirements at this point. God, I put Fred onto the chair before I streamed because Fred wanted to curl up in a little ball, but there is just one Fred fuzz that is fuzzing my nose. The subpoenas request relevant information. Just because it's relevant doesn't mean you can get it. They request admissible evidence. It doesn't mean you can get it from the defense attorneys. There's sufficiently specific negative ghostwriter. The documents are not otherwise procurable. They are from the government. Oh, sweet tea. I don't even know. The materials sought by the subpoena are not protected by privilege. I can't wait to see what the court does with this. Okay, I just need one sentence. How are we getting that this is not protected? The joint movements have the burden of identifying the documents as to which they claim privilege. You asked for all of their notes. You're not going to get to, your subpoena's not specific enough to shift the burden on they have to identify which document that they're claiming privilege. They're like, we're claiming privilege to our notes. We haven't even got to Triller yet. This is Trillery shit right here. With respect to each, how do they identify each document when you asked for everything? They need to show that it was a communication between client and counsel, which was intended to be kept, in fact, confidential and made for the purpose of obtaining and providing legal advice, like a proper session. Oh, and they're talking about attorney-client privilege, not attorney work product. They're not talking about work product. They are just, this is talking about attorney-client privilege. They're not talking about work product privilege, which is going to break down a little differently. The burden cannot be met by mere conclusions. Yeah. Hey, look, they got to Ipsy Dixit. It's like being in law school in here. We're not at race ipsiloquitur, but we're at Ipsy Dixit assertions. I'm in love. Okay, there was something worth reading on for just for the sheer joy of getting some Latin phrases thrown in, because why the fuck not? You know what? Maybe she does need Kim Kardashian on her legal team. Kim Kardashian's way familiar with the concepts of 1L and probably wouldn't think that this type of subpoena would fly. Oh, here we get to work product. Okay, good. We did get to work product. Let's be fair. The designation of material as attorney work product does not necessarily make it undiscoverable. Work product may contain two types of documentation: recital of factual matters, such as verbatim notes of a statement, and two, notes reflecting an attorney's opinions, conclusions, mental impressions, and legal theories. The second group is entitled to heightened protection. However, not every item which may reveal some inkling of a lawyer's mental impressions, conclusions, opinions, or theories is protected by work product. But you didn't identify anything specific. Oh my. And then it gets into the exhibits, including a hearing from December 17th, which will be fascinating. And I look forward to getting into that hearing transcript next week. OMG with this. Well, that's what's going on with Jen Shah. We need a case brief. We need a case brief. We need to talk about quashing subpoenas. We apparently need to revisit attorney work product privilege and whether or not Kim Kardashian has become part of her legal team as a consultant, because Kim Kardashian is not a licensed attorney, so she couldn't join as a lawyer, but she could probably join as a consultant. Though most of her work seems to be after someone's convicted, so maybe she'll join the team after Jen is convicted and goes to prison, and then Kim can decide if she wants to take up that cause. Yikes. Those motions to quash aren't going to go well. I'm very excited to see what the court does. But the biggest mystery is the sentencing of Stu Chains. Like, what happened to Stuart? Why hasn't he been sentenced? Why weren't there sentencing memos? And why wasn't there an item putting it over? I have questions. And that's the most interesting part, really, about all of this, because those motions to quash are just enjoyably laughable. Let's talk about the Kanye West, Kim Kardashian divorce of it all. Just going to say, as I said at the beginning, I talked about obviously how we treat topics of mental health. We do not diagnose people in the chat. Kanye has been open about some of his diagnoses. It is not an excuse for his behavior, but we're also not going to malign anyone in the chat. It is hard when the behavior is abusive, and we can talk about the behavior without besmirching the individual, as we do in our chat. Thank you, law nerds. You are incredible. Let's go through the latest filings and kind of break down what happened. I think quick road so far. Kim Kardashian made a motion for bifurcation of the divorce. Bifurcating the divorce means that you can be declared legally single. You can do the status only, the marital status only, and be declared legally single, and then decide the custody of the property separate and apart from that. So there are two avenues to go with that. The divorce was filed over a year ago. At the beginning of this, I need to go back and find my video so I can react to me being like, oh, they have a prenup, and it looks like the attorneys are working behind the scenes, and this should all be predetermined. So it should be 6 months, and then they sign off on a custody order, and it should all be done. Wrong, Emily. Wrong. Wait, did I do the wrong one? That was supposed to be the want one. Damn it. Which one did I do? I was supposed to do the want one. I can't hear myself, so I don't know. I don't know what I played. It was supposed to be the want one. I've done it badly. We were supposed to do that. So with that, the motion for bifurcation came as it was clear that they weren't going to be able to, I think, come to some decision about the prenup, and Kim wanted to be declared legally single, which I totally get. Like, It's been a year. I feel it. So let us go with what the court order said. Wait, no. First, there's the motion for substitution of attorney. Let's do that first. I was very surprised that this came a day before the hearing, where Kanye, yay, yee, yay, yeah, yay, switched out lawyers, which is, I mean, it's a choice. I, I'm just going to give my speculation. Here's my speculation. Oftentimes when oftentimes when individuals pull this, it is a delay tactic because the new attorney will often say, I need a little bit more time before the hearing. I've just switched attorneys. Often it is a stall tactic. This happens in civil and in criminal. A lot of times the courts don't fuck with it. They're like, no, you have to be ready. So on March 1st, Kanye separated from Christopher Melcher, who y'all on the interwebs are familiar with Melcher. He is, he seems like a really pretty level-headed, reasonable, conscientious attorney. But also the job of an attorney is to tell your client the truth and what is going to happen. And when you've reached, ethical attorneys will tell their client, we have reached the end of what we can argue for. We have, there's not much else we can do here. Attorneys that I think are not acting in their best ethics will say, oh, let's keep trying this, which burns client money. I get the sense, and this is just my impression, that Melcher would say, we have reached the end of what we can argue legally and ethically, and this is where we're at. That's how I perceive him as an attorney, just based on the things I've seen him share on social media and the commentary I've seen him give. That's just my perspective. So that might have been the case, or this might have been a delay tactic on Ye's part. So they switched out lawyers. So there you go. Kanye switched lawyers. They let Kim's attorneys know the day before the hearing. Interestingly enough, let's talk about this hearing. Where's my minute order? My minute order should be right here. Not the one I was looking for. There was a minute order missing. Did I do it wrong? No. No. Why? Why is my minute order missing? So annoyed. Let me see if I can find it real quick. Because the minute order shows who showed up and what they did. And this should be on my desktop. Where is it? That's it. There's the minute order. Why aren't you in my Google Drive? Y'all, we're professionals here. And it says it's already in the drive. Why don't I see it? Whatever. This is the way it's gonna be. We showed up for the book fair a week early. This is how my life is going this week. All right. So here is the minute order from the March 2nd hearing. Let's see who was all there and what they were all doing. Kim Kardashian West, petitioner via Court Connect. Laura Wasser, attorney present in court. Ashley Montgomery, attorney for petitioner. And then the new lawyer, Samantha S., was there for respondent. No, notice who's missing. Who didn't show up? There's no Ye. Maybe he was getting ready to drop his music video that went live on Instagram after this. Because there's no Ye in court. Ye didn't show up. No Ye. None at all. No Ye, no Ye, no Kanye, no nothing. The matter is called for hearing. The petitioner is affirmed and testified. Petitioner Kim Kardashian. So Kim testified about the bifurcation. The court grants termination of marital status. They are divorced. She is single. The court restores the petitioner and respondent to the status of unmarried person as of the date of the entry of this judgment. Counsel for petitioner and respondent jointly present to the court with the proposed judgment on status, which the court signs and causes to be filed. And it's done. Notice is waived. That's it. Bippity boppity single. So they are now legally divorced for status only, meaning they are single individuals. They are no longer married. It does not mean the divorce is done, because they still have to deal with the issues of marital property, even though there isn't any marital property, they've said, but marital property and child custody, that still has to happen. So until that happens, this is not done, but they are legally single. The notice of judgment, just for curious peepers, is exactly what it is. Notice of entry of judgment, status only, dissolution, status only, which means divorced, done, done, done. And Kim will be restored to Kim Kardashian and has already changed her name on social media back to Kim Kardashian. I don't know if the KKW brands, the Kim Kardashian West brands, will go back to Kim Kardashian brands, if they will rebrand. I don't know. But that is the end of that. You guys know what I think about the music video. A lot of you in the chat were saying that the video's already been taken off of his Instagram. I'm just gonna check real quick because I wouldn't be surprised if he took it down. There definitely was a lot of backlash about it. Um, so you know what's interesting though? He legally changed. He wiped his Instagram. Well, that's fascinating. He legally changed his name to Ye, but his social media name is still Kanye. I mean, it's Ye. Couldn't he change both? Maybe not. So the only thing that he issued was a statement about his divorce. So everything's down. All, all his all. I wonder how long that took. So all of it's down. Um, yeah, that's interesting. That's interesting. The video was a whole lot, but again, if you want to see my thoughts on that, at the Emily D Baker on Twitter is where I shared that, and I will go and screenshot those and reshare them to Insta for the people who don't do the Twitters. It was also in an LA Times article, and I will share that on the community tab here. I think that was the first time I've been quoted in the LA Times. Very exciting. Not that Twitter cares. We should get into new filings. We're going to do Cardi B first, and then we are going to get into the main event. There is so much. There is so much. But with all of this, I hope that the artistic expression is not an escalation of Kanye's behavior of control over Kim Kardashian. I think that this entire thing playing out in public is going to potentially be damaging for the kids. And I think that the video and everything that he has done on social is going to harm his chances at custody with the kids, which always makes me sad. But Kim is going to have to do what she feels is best to protect her kids. And she might feel that that is not having him with them as much as he would like, and that video is not going to go well for him in court when it comes to issues of child custody. So hopefully he has people around him who can support him in realizing that this was not the approach, even if he thought it was funny. But his kids are going to see all this play out one day, and it makes me sad for them. And it's got to be scary for Kim and for Pete Davidson, because it's not just Kanye. He has fans. So, all right. If you guys want to find the video, I'm sure it's still re-uploaded on the socials, but we should move on. I said we were going to talk about Cardi B. It's time to talk about Cardi B and Tasha K. There's more. But wait, there's more. There's more. In the Cardi B Tasha K lawsuit, I can't say conviction. It's a civil suit, Emily. The finding of liability, the final adjudication at the trial court is not the end. But wait, there's more. So what we know, Tasha K was found liable for defamation, intentional infliction of distress, invasion of privacy, etc. against Cardi B, was ordered to pay almost $4 million in damages. I've gone through the trial, the kind of day-by-day breakdowns, the final judgment verdict forms, the final judgment forms, all of that. I mentioned this a few videos ago that there was a note that there would be a hearing on injunction. My speculation at that time, just seeing the note on the docket, was that Cardi B was going to be seeking a permanent injunction to keep my name the fuck out of your mouth. And that is what we are going to be getting to. So let us get to Cardi B's brief in support of a permanent injunction to keep my name out of your fucking mouth. That is not, of course, its actual title. And it's actually probably with regard to all of the videos and the statements that have been made previously. Because here's the thing, I'm going to talk about it. I'm also not going to talk about it just yet. We've seen Tasha K's video where she said, I'm going to fight this to the Supreme Court if I have to. My First Amendment rights have been impeded. I've done nothing wrong. I think if I'm Cardi B's legal team, I'm looking at the way Tasha K has responded to this verdict going, oh yeah, she doesn't care. So they have got to go further to protect their client and seek the permanent injunction from the court. And Tasha K has said publicly, A, she doesn't have the money to pay this, and B, that she is not going to stop until court tells her she has to. So this is the next step of the court telling her she has to. Background. Plaintiff Cardi filed this action because defendants Tasha K refused to stop targeting her with harmful and disgusting lies. For over 3 years, defendants have repeatedly and knowingly published false and defamatory statements about plaintiff, that plaintiff engaged in prostitution, that plaintiff has herpes and HPV, that plaintiff uses or has used cocaine, that plaintiff appears in a particular video, engaging in a debasing act with a beer bottle. I covered that motion that broke all this down in detail. It's still up on the channel. If you want to know more about that, you can go find that video. We're not getting in that at all. Where did we go? Debasing acts with the beer bottle. Sorry, I always get sidetracked with the debasing acts of the beer bottle. And that plaintiff committed adultery. The verbatim defamatory statements published by defendants and admitted when she testified. She admitted that she said this shit. Admitted at the recent jury trial in this case include the following. Should we footnote voice it? Look, these are citations to the transcript at the trial. This is trial testimony. Okay. Tasha K. There's a lot that you spilled. You said that Cardi is a prostitute. She was a drug user, cocaine and Molly to be specific. She has herpes. Jones, yes. KB, you said that Cardi B prostituted. Jones, yes. This is from a Stormy Jones interview. Tasha K, was this Cardi's first time prostituting that you knew of? Jones, this was her first time prostituting that I knew of, yes. So this is from the videos that were played before the jury. Cardi B prostituted for a living. I co-sign everything that Jones said, that she's a whole prostitute. She's mad because I called her a prostitute. Bitch, you sold kitty cat. Can I say pussy on YouTube? Guess we'll find out. Meow. Context, YouTube. Context. We're going over court records for educational purposes. I do know this. For her to come out here and say she's never sold kitty, that's a lie. That's a motherfucking lie. The fact that I can say motherfucking and have to think twice about whether I can say puseta is confusing to me, but we're just trying to figure it out. Defamatory statements that plaintiff has herpes and HPV. Tasha K, she has herpes. Jones, yes. Tasha K, there's a lot that you spilled. We went over that before. I thought we left you and your confirmed irritated kitty in 2018, #herpes B. This feels like some junior high level bullying shit to me. I know you got HPV. What's the hashtag? Cold sore B? We're going to be talking about cold sore B tonight, bitch, since y'all should have had a motherfucking gag order. We'll see, bitch. Well, they're going to try to get it now with the permanent injunction. So I feel like maybe they should just quote this back to the court and be like, Miss Tasha K said, y'all should have had a motherfucking gag order. We would like to do that now, please. Cardi Cold Sore B, I'm sorry, Cold Sore B, that's her name. We had a certain rapper, Cold Sore B, tweeting about us all night. Cold Sore B is done. Cold Sore B is done. Herpes B. Defamatory statements that plaintiff used cocaine. Tasha K, she was a drug user. Yes. Cocaine to be specific. Yes. Tasha, that was attached above. This was not above. Now, if the bitch is lying by saying that you're a cokehead, okay, by saying that you were addicted to Molly pills, by saying that you were a prostitute, why in the fuck are you coming at blogs for some shit that already went viral? Sue the bitch. She did, though. Defamatory statements about debasing act with a beer bottle. Oh, dear. Okay. Plaintiff stuck beer bottles up her vagina. She actually took beer bottles from pedestrians. This is on video. I've already said this when we covered the anti-slap, when we covered the summary judgment motion. This has already been out there. So, whoa. This is on video. She took the beer bottle from the pedestrian, stuck it in her cooch, drank the beer bottle, and gave it back to him. It's been proven that that was not Cardi B on that video. Cindy, why is it censored in the motion for the court? And it might have been censored. The video might have been censored for the jury, but this might just be censored for the court. Plaintiff is fucking someone else too. Oh, defamatory statements that plaintiff committed adultery. By the way, accusing someone of adultery in Georgia is defamation per se. Plaintiff is fucking someone else too. She also said that you fucking somebody too high profile and that's the reason you are done. Enjoy your transition, Dick. That's the only thing you ever gave her. Balls. Somebody is licking her buseta. Now plaintiff's fucking somebody else. I'm sure that means Cardi B. Who is Cardi's side peen? Could have we said peen the whole time? Make it so much easier for me. He works for Atlantic. He's up high on the Richter scale. Like he's making it shake. I don't understand. Is she quaking? I've got questions. Tasha K, Cardi's sleeping with somebody else. You don't know that. CK, is this her husband, CKB? You don't know that, Latasha K, but I do. My source told me that when have my sources lied to me? When? I'm waiting. Okay. Deep breath. Each of these categories of statements was supported at trial with overwhelming and unrebutted evidence establishing that the statements were patently false and defamatory and that defendants published them with actual malice and with the intent of causing plaintiff emotional distress. The jury unanimously found both defendants liable on each count, both being Tasha K and her company, on each count of plaintiff's claims and awarded compensatory damages, punitive damages, cost of litigation, which was over $1 million. When you're like, I want to know how much these types of cases cost, it was over $1.3 million in legal fees. I mean, Cardi B's lawyers seem to have done an amazing job. I like the way they write. All of their motions have been good. All of the reports at trial is that they were excellent. So, even though defendants were told on multiple occasions that the abhorrent things they were publishing about plaintiff were untrue, even though they admitted that they knew they were untrue. Wait, does it get to the 4 cease and desist? Yes, it does. Hold on. Emily, keep reading. Even though defendants were told on multiple occasions that the abhorrent things that they were publishing about plaintiff were untrue, even though they admitted that they knew they were untrue, defendants refused to discontinue, remove, or retract the defamatory statements. Indeed, despite the filing of this action and the receipt of multiple cease and desist letters, defendants' harassment continued throughout the years-long litigation as defendants purposely persisted in repeating the defamatory statements in order to upset plaintiff and drive traffic to defendants' platforms. CEG 11222, transcript at 2210-20. KB acknowledged that she tagged plaintiff using the hashtag herpesb in her posts to irritate the plaintiff. This was at trial. 10/7/19 video at 39:15. I just happen to have a personal vendetta against you, bitch. So I take pride in this shit. when y'all are like, how do people prove actual malice? Well, they just use the shit you say and do. And when you get multiple cease and desist and persist, it's one of the things that they tell the jury, look, they received multiple cease and desist. We told them this was untrue. And yet, and yet, and yet. Defendants have also made clear on multiple occasions that they will not stop repeating the defamatory statements unless compelled to do so by this court. For example, during a September 21st, 2020 video, a year and a half after the case was filed, Tasha K clearly explained her intentions. I don't care if you put a gag order on me. The reason the bitch is mad, I know y'all gonna put a gag order on me. I don't give a fuck. It's gonna be an injunction. I don't give a fuck. Well, here we are at the injunction stage, but it sounds like Tasha K is aware of the differences between an injunction and a gag order. I mean, there was a conversation somewhere where she knew the difference. Um this is continue should we just read them all? Sure. 10/7/19 video at 3:05. What's the hashtag cold sore B? We're going to talk about cold sore B tonight, bitch. Since y'all should have had a motherfucking gag order, we'll see, bitch. At 27, now on to cold sore B. Y'all should have had a gag order on me. I was just waiting for the right time and the right motherfucking receipts to strike again, bitch. 11/11/19 video at 4:15. She wants me to delete videos. Well, that sounds like the cease and desist letter probably was received. At least I don't know which one. She wants me to delete videos. Well, bitch, you need to give me a check. You want me to delete these videos? You better give me the money that I was supposed to make off the videos or more because it's residual income. You want shit down from my platform? You got to pay for that. Well, I mean, the things have changed a lot with that almost $4 billion judgment. 4/23/19 video. You want to shut me up? Let me tell you how to shut me up. Pay me, bitch. Well, okay. What's interesting here is that after 3 years of this going on, I think that they're right to have to file an injunction. But I also wonder how much in legal fees was spent with Cardi B's attorneys having to watch Tasha K videos. This is something I thought about way too much during the Toddy Westbrook KJ case. It's like how many hours did attorneys or paralegals spend watching these videos? And most attorneys want to watch them themselves because they will take away something else from watching a thing and watching it sometimes more than once as you're preparing to file a case or go to trial or send cease and desist. How much time was spent watching Tasha K? I hope they downloaded it so she didn't get the views. Because if you're going to sue someone, what you don't want to do is give them views. Speaking of giving views, have I mentioned that you all should go ahead and like and subscribe? We're almost at 199,000 subscribers. And yes, it matters. So don't forget. Like and subscribe. Okay, let's continue. It feels like the appropriate time to say that. When asked about her statements during trial, I love that we're getting trial testimony. Her testimony could not have been more unequivocal. Unless someone actually forces you to, you're never going to stop repeating these statements about my client. That's correct. Here's what we must say about Tasha K. Credit where credit is due. I think she's telling the truth. I think she's telling the truth. And I respect because you know you're fucked. Like at this point in a trial, unless someone forces you to, you're never going to stop repeating these statements about my client. Someone could get on the stand and be like looking at the jury going, no, I see now the error of my ways. I feel repentant. Tasha K was like, that's fucking correct. That's correct. Can't stop, won't stop. So the only way at this point these videos are ever going to come down is if the court forces you to. Is that right? That's correct. Are you essentially saying that to stop you from calling my client cold sore B, my client needs to get a gag order? Yes, ma'am. Okay. And when you say gag order, you're talking about an injunction order in court, correct? That's correct. She's like, I said what I said. And look, She seems to have been honest and forthright on the stand, because I still think that Tasha K doesn't think that she's wrong, that she thinks this is within her right to free speech. The thing is, defamation is not protected. Argument. Plaintiff is entitled to a permanent injunction. Suffered irreparable injury. Remedies available at law, such as monetary damages, are inadequate to compensate. Consideration of the balance of hardships between plaintiff and defendant and the public interest would not be disserved by a permanent injunction. Like the greater public is not going to be harmed by stopping someone from speaking. And you can stop someone from speaking in a defamatory way. Evidence entered at trial proved that defendants were unrelenting in their campaign of defamation against plaintiff, both before and during the pendency of this case. Defendants made clear that they would not stop publishing the defamatory statements about plaintiff, absent an order from this court. I think they did make that clear. I don't think that's a reach at all. If defendants carry through with these promises to keep harassing plaintiff absent an injunction, plaintiff will be required to file repeated, if not perpetual, subsequent litigation to redress the threat, which means the $1.3 million awarded in legal fees of the almost $4 million judgment won't be sufficient, because the legal fees will keep going up, because Cardi B will keep having to have her attorneys go to court to deal with this. I think that they have a very, very good chance of getting a permanent injunction granted on April 1st, I think is the day that this is going to be heard. They say this is particularly true if defendants are judgment proof and thus incapable of compensating plaintiff for the harm they have caused. Meaning, if defendant really doesn't have this much money and plaintiff is going to go bankrupt or try to avoid this judgment in some way, then you can't even compensate Cardi B for the almost $4 million that she has been awarded. Or they say, if defendants have fraudulently moved assets during the pendency of this litigation, to make it more difficult to collect the judgment, because then the damages award cannot serve its intended deterrent effect. Defendants have already boasted as much. Oh, here we go. This has been this video clip's been going around. I saw it on Kempire's channel, and I will link it. I will link Kempire's video where he talked about this. Tasha K, what? I'm like 600,000 in, but let me tell you how this was a blessing, though, because can't nobody else sue me. And even if they do, I ain't got no money. We've got estate lawyers. We've got every motherfucking thing. I ain't got shit in my name, bitch. Well, no wonder they're talking about whether she fraudulently transferred assets. That statement, if I was Cardi's attorney, I would look at that statement and be like, we've got estate lawyers. We've got every motherfucking thing. I ain't got shit in my name. I would look at that being like, oh, she moved things. That's exactly what I would be worried about. The guest said, trust. Tasha K said, exactly. Good luck with that. You know what I'm saying? People will back away. Oh, she's got to trust. Oh, let me just, okay, let me just leave her alone. And you can research it like, that is the biggest blessing. She's bragging about moving assets. I don't think that works the way that she thinks that that's going to work with this judgment, but she's bragging about trying to make herself judgment proof by saying that I don't even have enough to sue me for, so I can say whatever vile shit I want to say on the internet. This is not the direction we want these platforms to be going in. I don't think. Personal opinion. Tasha K, even if they did sue, bitch, I ain't got but $1 to my name. What are you going to get? And there's always bankruptcy. To everybody who was like, well, what are you going to do if she wins? What do you mean, what am I going to do? What do you do? I'm going to pull a 50 cent on that bitch. What are you talking about? KB talking about the verdict. I ain't got it. Don't ask me for no money. I ain't got it. We have business things in place to take care of things like this. Even assuming defendant satisfies the jury's substantial damages award, damages alone are inadequate to address the constant ongoing threats of defendant repeating the defamatory statements. In addition to the ongoing harm, statements are permitted to subsist and be repeated is irreparable. So let's see. They go on to say, likewise, the emotional harm to plaintiff that was intentionally caused by defendants, which plaintiff proved at trial, would also be irreparable if permitted to continue. And then they go into the third factor of the test, concluding, well, at this part, indeed, without an injunction, defendants could simply republish the same videos and written posts at any time. I think she took them down. Yeah, this addresses that. Okay. Defendants may argue that plaintiff will not suffer harm without an injunction because they already removed certain videos and posts. As an initial matter, not all of the videos and posts containing defamatory statements have been removed from defendants' social media accounts. Talking about you've got cold sores on your lip, that picture's on live, everyone can see that shit. Who's got a gag order now? Regardless, even with respect to videos and posts that have been taken down, defendants have made it abundantly clear that an injunction is necessary to prevent them from repeating and republishing the statements. Defendants previously removed the Stormy Jones interview and the video she posted a couple days later from their social media channels upon receiving a cease and desist, only to republish it the very next day. So I think that they have made a good case for why they need to be taken down. Larissa's in the chat saying she moved them to Patreon. I don't doubt that. And Kay Beachman said the videos are still on Patreon. So a number of you are, I'm seeing in the channel, a number of you are saying that they've been moved to Patreon. So they still exist. And so it's not improper for Cardi B to be seeking this. A permanent injunction is consistent with the First Amendment and Georgia law. The Supreme Court never held that all injunctions against speech are impermissible, right? Because defamation is not permissible speech, it's actionable speech. And then they go through the different types of injunctive relief. Plaintiff seeks a narrowly tailored injunction. This is what I wanted to get to. What does, hi Fred, what is Cardi B seeking with the injunction? Plaintiff seeks a permanent injunction that is not worded more broadly than is necessary. Oh, it's narrowly tailored. Not worded. Fred, you're going to unplug my mic with your face. Fred's like, I'm going to make myself comfortable on your lap, and there's nothing you can do about it. Plaintiff seeks a permanent injunction that is not worded more broadly than necessary. You can't step on my keyboard, though. To address the defamatory statements that were the subject of this action and that were found to be defamatory by the jury in this case. A proposed injunction will be submitted before the hearing on the issue in accordance with the court's instructions. I can't wait to see that. Specifically, plaintiff is only seeking to require defendants to remove any videos and posts that contain the defamatory statements from their social media accounts and to enjoin defendants from republishing those same statements. In other words, the proposed injunction will only affect speech that has been found defamatory and thus is not subject to First Amendment protection, which is consistent with federal and state law. Agreed. So that is the end of this. But wait, there's more. Tasha K has a filing too. We're going to talk about that, and then we're going to get to Klein quickly. We're going to do this quickly because y'all know how I feel about it. I think an injunction is appropriate, especially given the context of everything. Fred is like, you're not allowed to use the mouse. You need to pet me with that hand. That's the petsing hand. Okay. We're going to try to mouse with one hand and pets with the other hand. I can't, you are a large fluff. You are a very large fluff. I'm not surprised. I think it's probably going to be successful. I'm curious as to what Tasha K's lawyers say. Fred is rubbing his face on the end of my mic to push my mic. Well, not to push my mic into my face because he wants to rub his face into the mic, but it pushes the mic directly into my face. So he just wants to be pet on the face. I did boop the floof. We've booped, we've pet. He's not going to go back to the chair. He's not going back to sit down. He is like, we're here on the desk for the rest of the night, and there's nothing you can do about it. All right. So Tasha K filed a memorandum of law regarding injunctive relief. Oh, I've made this too big. Okay. At the conclusion of the jury trial in this case, the court ordered the parties to reach and submit a memorandum detailing the applicable law on injunctions for the court's consideration in advance of the April 1st hearing regarding injunctive relief. We all knew this was coming. Legal standard for a permanent injunction. It must be noted that during the entire pendency of this case, plaintiff never requested a temporary restraining order or preliminary injunction. Furthermore, no motion for permanent injunction has ever been filed. Plaintiff requested injunctive relief solely in the prayer for relief section of the complaint, which they're allowed to do. That is their choice. The case at bar is a diversity action. We know it's a divert. Okay. Fred is now drooling on me. Do y'all have cats that drool? Fred is the first cat I've had that drools, and he drools so much. The case at bar is a diversity action with no issues or claims rising from federal questions and is therefore governed by Georgia state law. A federal court sitting in diversity applies the substantive law of the state. Great. Entry of a permanent injunction is appropriate only in clear and urgent cases where there is a vital necessity to prevent a party from being damaged and left without an adequate remedy. Do we think that we have such a case here? What do we think Tasha K will continue to do? Like, if Tasha K continues to hashtag herpes B and to republish those videos or publish them on Patreon or continue to make those statements, what else can Cardi B do? She can try to enforce the judgment. But if Tasha K's like, I don't have the money, have fun with that, I'll file bankruptcy, she's not deterred in any way. So what else is a deterrent effect other than an injunction, which when she violates can then be enforced more? Equitable relief is a matter within the sound discretion of the trial court, and the grant of a permanent injunction is to be sustained on review unless the trial court has manifestly abused its discretion. Why are we getting to what the appellate court's going to do? Don't care. We know the trial court has discretion to do it. Plaintiff must prove that she is suffering and will continue to suffer. At trial, they found that there was a intentional infliction of emotional distress claim. I don't know what else you want plaintiff to prove. Plaintiff has proved it, which entitles her as a legal right to injunctive relief. In addition to the showing of a real and imminent threat of future injury, plaintiff must prove that the compensatory and punitive damages awarded are an inadequate remedy. I think that the plaintiff has done that. Conclusion, plaintiff has the burden to establish there's a necessity. Your Honor, here's the law. It's on plaintiff. We don't have much more to say about that, which I think is the only response the defense could come up with at this point, because the defense can't argue this with a straight face because, their client said, get an injunction, bitch. And Cardi B went, all right. That's where we're at now. So I think that will be granted. I am going to try to attend to that hearing as well, because because I want to hear what the court says. I am very curious, and that's the end of that. We need to get moving on. At an hour and 17 minutes in, we have so much left to cover this evening. Fred, not this. Are we done? Okay, you're just going to chew on the mic. I'm sorry if you hear him chewing on the mic. Please don't hit me in the face with it though, because that's not helpful. And we're gonna swoop and we're gonna do a quick road so far. I'm not gonna do a ton of a road so far when we talk about Ethan Klein, Ryan Kavanaugh, and the trillerness of it all, because it's really well laid out in the motion, and I don't want to repeat myself more than absolutely necessary. But there have been multiple lawsuits between Ethan Klein and Triller. If there's any law nerd foot soldier crossovers in the chat, go ahead and throw some footsies in the chat. You guys know how I feel about this lawsuit. I try to look at these things from both sides. After Triller filed the state lawsuit, and the state lawsuit looked like it was going down in flames, I do not have any chill when it comes to Kavanaugh filing this additional suit. I think there is no legal basis for it. I think it is harassing, and I think it is bullshit. So, with that in mind, those are my own biases with this lawsuit. Fred, thanks, buddy. Because the copyright suit is still going. The copyright suit aside, the things that Ethan Klein has said about Ryan Kavanaugh, though Ryan Kavanaugh is surely not thrilled by them, are not defamatory. So using the courts to harass people is horseshit, and it's weak. And I don't like it. And I don't like this lawsuit. I think it's dumb. The best thing about this lawsuit was the night I drank whiskey and read it, and we got to talk about the Keemstar and the Trisha Paytas of it all, because all of that was in Kavanaugh's complaint. So if you want to look at it, I'm pretty sure I have an H3 playlist on the channel, but I will link it down below because that lawsuit, it gave us things. I mean, it wasn't as trillery as the other Triller lawsuits because it was not just Novian and Novian, the law firm that did the Trillery shit. It was another law firm with Novian and Novian, but it laid out an entire adventure of the history between Ethan and Keemstar and Trisha, and I couldn't tell why any of it was relevant. And it was a journey. It was a trip and we took it. So let us just get into this 886 page anti-slap motion. Don't fear, moderators. I love you. We're not going over all 886 pages. We're not going over every single exhibit here. This is a thorough motion. I previewed it so we can kind of scoot through it. The attorneys that Ethan Klein has hired have really done an excellent job. I think the new lawyers for Kavanaugh are better than the Trillery lawyers, who you know how I feel about. They filed a complaint without any fucking dates in it, and I lost my goddamn mind. So, you know, we need some more lippy for this, and we need to just get ready. So let us go. Let us go. I don't know what sound what sound. We need a sound. We swooped. Let's hope we get the one that I'm thinking of in my head. That was the right one. I've got to. All of you are like, Emily, just put notations on your soundboard. Yes, I could do that, but it takes the adventure out of it. And the little ADHD rebel in me kind of likes the adventure. All right, y'all. Take a breath, get a drink, get some popcorn. We got 886 pages incoming. So let us get into it. Also, I've redacted parts of this because there were times that Triller's lawyers sent stuff to what may or may not be Klein's either business or home address. I wasn't sure. I wanted to redact that out, especially given recent things going on with people trying to show up at Ethan's house. I consider all of that to be very inappropriate, scary, and harassing. I also I may post this if you guys want to read it. I want to make sure that that's something that Ethan would be okay with. And I want to make sure that I've redacted out any other references to it before I do that. So I know it's redacted for the purposes of covering today, but if I'm going to share it, I just want to make sure that that is something that is okay. We're going to share it now. Defendant's notice of motion and special motion to strike. This is an anti-slap. We've talked a lot about anti-slap motions on this channel. Anti-slap motions are motions against strategic litigation, against public participation. They allow the lawsuit to completely end before it begins. Ethan Klein has already, I shouldn't pull this up yet. Ethan Klein has already won an anti-slap against Triller, which means Triller will have to pay legal fees, etc. And I think they have very good standing on this one as well. So we're not going to get into all of the law of it because it's so similar to the other law. It's so similar to the other anti-slaps that we've gone over. We're going to get into the facts, and we're going to get into the shade, and we're going to get into the Ethan Klein declaration that gives us some more information than we've had on this. I mean, we haven't had the receipts for all of it yet. That said, some of this might have come up on the H3 podcast. I have not seen every moment of every podcast episode, so it might have come up. Memorandum of Points and Authorities. The complaint of plaintiff Ryan Kavanaugh describes him as a television producer, entertainment executive, and entrepreneur who is devoted to philanthropy and volunteering. Here are the words that the press, Kavanaugh's former business partners, acquaintances, and colleagues have used to describe Kavanaugh: pariah, false prophet, con man, big into falsehoods, unpopular, and controversial, to name a few. They just went there, just there. Went there. Indeed, as one of Kavanaugh's colleagues said, quote, every time someone lies in cans, Ryan Kavanaugh gets a royalty. Footnote 1. Kavanaugh's reputation is forever marred by his colossal business failures. He touted developing an algorithm that could determine the profitability of TV shows and films. He was exposed as a charlatan when his media company, Relativity Media, underwent two of the most calamitous bankruptcies in the entertainment industry. Just all the way there. I imagine that Ethan's lawyers had fun writing this. They got to say calamitous. We're going to have to pick up another Relativity Media case. There's another one floating out there that I've been holding off on, and it's going to be a worlds collide. We will have to. We'll have to. Haunted Shadows. I pronounce things badly all the time. It's probably pronounced con. I don't know. I'm not fancy. I don't know things. There are some things I do know. Okay. Calamitous bankruptcies in the entertainment industry. These are all footnotes to a declaration that has a whole bunch of other stuff. We're not going to get into a lot of the footnotes. Kavanaugh's reputation is also forever tarnished for being a liar and a fraud. Aside from his quote-unquote algorithm being exposed as proverbial snake oil, he has pathologically lied about his business dealings. He has also lied under oath about his role in fabricating a memorandum alleging Relativity's former president, Adam Fields, engaged in sexual harassment. The final defining characteristic of Kavanaugh's reputation is that he looks like Harvey Weinstein. The final defining characteristic of Kavanaugh's reputation is his insatiable and vindictive need to silence criticism. Even though Kavanaugh relies and thrives on the protection of the First Amendment for his business of producing, quote, more than 200 films generating more than $17 billion in revenue, end quote, his admiration for the First Amendment goes out the window if anyone criticizes him. For example, after Mr. Fields exposed Kavanaugh's false testimony and fabrication of evidence, Kavanaugh retaliated by suing Mr. Fields. Indeed, Mr. Kavanaugh has threatened the press with lawsuits on numerous occasions to kill negative stories about him. Defendants Klein, TEI, collectively defendants, are the most recent victims caught in Kavanaugh's crosshairs. On April 22nd, 2021, defendants produced a podcast episode that used 45 seconds of a 4-hour broadcast of a boxing match produced and owned by Triller Fight Club 2 LLC, an entity owned by Kavanaugh, to criticize the fight. Unable to withstand defendants' mockery, Kavanaugh caused TFC2 to sue defendants for copyright infringement. When defendants began to publicly criticize Kavanaugh and the company he owned, Triller Inc., Kavanaugh caused Triller to sue defendants for tortious interference, the lawsuit that they already lost. On the eve of that lawsuit being dismissed on an anti-Slapp motion, Kavanaugh initiated 2 additional actions against defendant. 1, the present lawsuit, and 2, a uniform dispute resolution program action. Kavanaugh went on to make social media posts placing a bounty on negative information about defendants and directing people to report Ethan to the FBI upon false allegations of inciting death threats and harassment. I mean, it's a lot to take in. Defendants have made numerous podcast episodes discussing a wide variety of Kavanaugh scandals. The complaint, however, focuses only on one scandal discussed by defendants, a June 7th, 2019 article from Variety magazine that reported on a verified complaint filed by Kavanaugh's former business partner, Elon Spar. In the verified complaint, Spar alleged under oath that Kavanaugh made numerous fraudulent statements to him and Kavanaugh operated his business as a Ponzi scheme. We've covered that complaint. It says those things. Kavanaugh claims that defendants repeatedly referenced the Variety article and its headline, Ryan Kavanaugh accused by ex-business partner of running a Ponzi scheme. How many times have you heard that sentence? Is defamatory. The sole evidence Kavanaugh provides for provides of falsity is that Spar withdrew the verified complaint and his post-settlement statement that his quote unquote Ponzi scheme allegations were not accurate. Here's the thing though. When you settle a lawsuit, you say things. It doesn't mean when you swore the declaration it wasn't true. You're just saying maybe it wasn't accurate, but he did in fact characterize it that way under oath. Defendant's statements about the Variety article and the verified complaint are not actionable. I agree. To determine whether the challenge statements explicitly or implicitly contain a false assertion of fact, this court must conduct a two-part inquiry. One, examine the challenge statements themselves, and two, examine the context of the statements. And then they get in to talk about why the challenge statements aren't defamatory and recite it fairly concisely. First, the challenge statements are not defamatory because they are true. Kavanaugh's ex-business partner did accuse Kavanaugh of running a Ponzi scheme, and it was reported by Variety. Since Kavanaugh is a public figure, it is his burden to prove falsity, which he cannot do because mere denials, like Spar's statements in the Variety article, are insufficient to prove falsity. Hello, cat. Stop stepping on my keyboard. Second, even assuming the challenge statements stated that Kavanaugh ran a Ponzi scheme, which defendants have never said, it is well established that accusations of criminal conduct are not actionable when the source underlying the accusation is disclosed. They're talking about like a re-reporting. Defendants repeatedly disclosed that the challenge statements were based on the Variety article and that the verified complaint embedded in the Variety article, which we've gone over on this channel. The complaint is literally in the article, and you can read the entire complaint, the whole thing, which we did on this channel. Third, the context of the challenge statements further demonstrates that they are not actionable. Actionable statements contain indicia of firsthand or specialized knowledge. Defendants expressly disclaimed any such knowledge regarding Spar's allegation. Non-actionable statements usually involve caustic and hyperbolic language, particularly when set in context of a legal dispute. Fourth, the true and fair reporting privilege of California Civil Code, Section 47D applies. Publications that report on news and current events on a weekly basis, like defendant's podcast, are entitled to this privilege, so long as defendant captured the gist or sting of the filing in question. You cannot misrepresent a statement. You cannot pull up a court document, misread it, misinterpret it, and say, this document says this person did this, if that's not what it said, and if it's not the gist of what it said. But what you can say is this document says, quote, you did X. You can report what a document says. You can't falsely report what a document says, which is why most people just stick to saying this document says this. I don't know if it's true or not. That's what's alleged because allegations and shade. Where do you want to go? You want to go over here? Go on. Fred just wants to be all over my desk and lay on my keyboard. Fifth, even assuming the challenge statements contained false assertions of fact, which they do not, Kavanaugh cannot meet the burden to prove by clear and convincing evidence that the challenge statements were made with actual malice. The allegations of the verified complaint, it's perfect that we're covering this with Cardi B, because when we look at the actual malice in that versus what was said here, the distinction is really striking. And you can see the distinction based on the statements that Klein has made that will be highlighted here in a bit versus the statements that Tasha K made. And it makes it easy to see where you get some delineation of actual malice. Let's see. Finally, Kavanaugh cannot prove special damages. Kavanaugh is limited to special damages because he sent defendants a defective correction letter under California Civil Code Section 48A, and within 2 days, defendants clarified that Spar withdrew his verified complaint. The only special damages Kavanaugh comes close to alleging with sufficient particularity is that the challenge statements, along with defendants encouraging viewers to review Triller's social media on the Triller app, caused Triller to lose millions of dollars. Fred. Thanks, buddy. The January 12th, 2022 order granting defendants anti-Slapp motion in the tortious interference action held otherwise. Not only are the challenge statements protected by the First Amendment, Triller failed to demonstrate defendants' conduct caused negative reviews or resulting damage. They've already got a ruling against them. At bottom, Kavanaugh's complaint is but another example of Kavanaugh abusing the judicial system to silence lawful criticism. Fortunately, California Code of Civil Procedure, Section 425.16, the anti-SLAPP statute, provides defendants the mechanism to expose Kavanaugh's latest fraud. They're just going in. They are done with this. All done. And I can see why they are. After winning the other anti-SLAPP, to continue to have to fight essentially the same lawsuit in a slightly different way is preposterous. And then they go into the prongs of the anti-SLAPP. The burden is going to shift. So the anti-SLAPP has two prongs. The burden, Klein is going to meet his burden. The burden is going to shift onto Kavanaugh, and I don't think Kavanaugh will be able to meet that burden. And this will also get slapped right out of court. Summary of facts. We're not going to go through all of this because a lot of this is in Ethan's declaration, and we are going to go through that very thoroughly. Kavanaugh was the founder and former CEO of Relativity. He claimed that he developed an algorithm. This is all up above. The Honorable Terry Friedman held that Kavanaugh lied under oath about the origins of a memo that Kavanaugh fabricated and falsely claimed Relativity's former president, Adam Fields, engaged in sexual harassment. Kavanaugh also lied about his charitable contributions. He has faced numerous lawsuits alleging fraud and failure to pay. All of this caused Kavanaugh to be shunned by the entertainment industry. Kavanaugh established a new media company called Proxima Media. Sometime in 2019, Proxima became the majority investor in Triller, a social media platform. Kavanaugh calls himself Triller's co-founder, and the media often describes Kavanaugh as Triller's owner. Hey, Kavanaugh, your shit is flipped. The Spar lawsuit and its media coverage. In June 2019, Kavanaugh's ex-business partner Spar filed in Los Angeles Superior Court the verified complaint, which was drafted by Sidley Austin, which is a very prestigious law firm, detailed numerous fraudulent statements by Kavanaugh and claimed that Proxima was a Ponzi scheme. In response, Kavanaugh filed an unverified complaint alleging inter alia that Spar disparaged his former employer. On June 7th, 2019, the well-known entertainment industry news outlets Variety, Hollywood Reporter, and The Wrap published articles about the dispute. The media accessed both complaints through LASC's media portal, which provides public access to the filings the moment they're submitted to the court. If the filing has not yet been fully processed by the court, it will have an unfiled watermark. Both complaints were withdrawn prior to being fully processed. Kavanaugh's representative contacted various media outlets and claimed the articles were defamatory. Kavanaugh's representative stated that the complaints were submitted to the court by accident. Sidley Austin doesn't make that kind of accidents. It was a shot across the bow is what it was. It wasn't an accident. It was a warning shot because they were trying to settle, my opinion. Let's see. And that they were not intended to be legally filed. Kavanaugh himself admitted that his allegations that Spar disparaged his former employer was, quote, not accurate. Spar made a post-settlement statement to the media stating, to my knowledge, based on the information provided to me, Kavanaugh has and is investing heavily in this business, and any reference to ESX or any related business as a, quote, Ponzi scheme, unquote, is not accurate. It doesn't mean it's not. He doesn't say it's not true. He says it's not like exactly a Ponzi scheme because it's like not an illegal enterprise. Kavanaugh himself admitted that his allegation, Kavanaugh himself admitted that his allegation that Spar disparaged his former employer was also not accurate. Kavanaugh is a visionary thinker, and I wish him the best of luck in his future endeavors. Spar did not explain what information he reviewed, whether a financial audit took place, and why his opinion of Kavanaugh shifted 180 degrees within a few hours. Some media outlets included the post-settlement statements, while others did not. Kavanaugh did not sue the media outlets over their various articles reporting the verified complaint. What I want to happen and think will be fascinating is when and if the basis of the Variety article being that unfiled or that unverified complaint. The verified complaint that was not formally filed yet. Whether they will get the settlement agreement in discovery between Kavanaugh and Spar, because Klein's side will want to know why the statements were retracted so quickly, and I think they would have a right to any settlement agreement, which would be fascinating. The copyright action. We have covered the copyright action here. This is the action over the use of the clip of the Ben Askren fight for commentary on the podcast. The crux of it is that they're upset. I don't think they can get to it because it's fair use, but they think they can get to it because Ethan or his team or someone uploaded to an unlisted video on another channel the clip of the fight that they were using for commentary, and that because that segment was viewable, that link, the like the numbers at the end of the video was viewable, that people could theoretically type that in and go look at the video. That's what their beef is now. They say that Triller Fight Club 2's counsel, who also represents Triller Inc. and Kavanaugh, informed defendants that Kavanaugh was behind the copyright action. Previously, defendants were completely unaware of Kavanaugh. To fraudulently induce third parties to participate in its settlement program. This is new tea, by the way. This is new tea to me. To fraudulently induce third parties to participate in its settlement program, Triller Fight Club 2 demanded that defendants falsely state, 1, that they paid millions to settle when less than 1 million was demanded, and 2, that Triller had embedded watermark technology unlike anything defendants have ever seen without providing information to defendants about said watermark. Defendants' public response to the copyright action, we know that Klein went on to talk about it a lot. On July 8th, Ethan tweeted a joke stating that he thought of the Variety article when he thought of Kavanaugh and included a screenshot of the Variety article. The majority of the comments on the 7/8/21 tweet did not reference the Variety article. In response to comment referring to YouTube celebrity Jake Paul leaving Triller for Showtime, Ethan responded that he did not know the cause, but Showtime was a better opportunity, and the move was unsurprising. Kavanaugh and Triller's response to the June-July podcast. On July 11th, Kavanaugh sent Ethan Klein a threatening DM. Don't worry, there's pictures of it attached. On Instagram that concluded with govern yourself accordingly. On July 13th, 2021, Kavanaugh sent defendants a demand for retraction that was authored by the attorneys representing Triller Fight Club 2 in the copyright action. The 7/13/21 letter failed to identify the alleged defamatory statements or how they were false. Rather, the letter only contained the excerpt from the Variety article of the post-settlement statements of Spahr and Kavanaugh's representative. On July 14th, right before the parties were to meet and confer in the copyright action, Triller sent defendants a draft copy of a tortious interference claim that were authored by the attorneys representing Triller Fight Club 2 and Kavanaugh. That was the other action that's now been dismissed with prejudice. Out of an abundance of caution and to demonstrate good faith, on July 15th, 2021, defendants produced a podcast episode that discussed that Spahr had withdrawn his verified complaint. The tortious interference action has been dismissed with prejudice. We've covered it. That coverage is up on the channel. Defendants' public response to the tortious interference action from mid-July through November. Defendants released additional podcasts discussing Kavanaugh and Triller. On September 3rd, 2021, defendants held a contest about which memes of Kavanaugh should be put on a shirt. The memes were parodies of music albums. The winner was a parody of Kendrick Lamar's Damn with the caption scam. Don't worry, we'll go to the pictures. On October 21st, TEI announced the creation of a website, Does Ryan Kavanaugh Look Like Harvey Weinstein.com, the parody website. The parody website uses humor to comment on Ethan's opinion that Kavanaugh physically resembles Harvey Weinstein by using interactive features like photos and games. Don't worry, it's also attached. On November 1st, 2021, TEI released a t-shirt depicting a courtroom sketch of Ethan and Kavanaugh, the parody shirt. Ethan is depicted as in his judge costume from TEI's Content Court series, a mock trial series where a public figure is criticized for their online content, and Kavanaugh is depicted as the defendant. The bottom caption of the parody shirt was the final line from Kavanaugh's 7/11/21 DM, govern yourself accordingly. In the November 1st, 2021 podcast, Ethan explained the parody shirt depicts him sitting in judgment of Kavanaugh and prevailing over the various lawsuits. This present action, we are aware. The complaint alleges that the challenge statements were defamatory, that Kavanaugh suffered damages from defendants alleged inciting viewers to review bomb the Triller app. Kavanaugh has also made several bizarre social media posts, such as placing a bounty on negative information about Ethan, falsely stating Ethan directed harassments and death threats to Kavanaugh, his family, and friends, depicting or directing people to report Ethan to the FBI, and alleging conspiracies against Kavanaugh by Wikipedia and its editors. Defendants responded with more podcast episodes that discussed, inter alia, the present lawsuit, social media post, and the additional articles. The January 12th, 22 order and aftermath. On January 1st, 2022, the court in the tortious interference action issued an order granting defendants anti-Slapp. The court found that defendants satisfied prong 1 because Kavanaugh was the matter of public interest and YouTube and Reddit were public forums. 2, defendants did not incite negative reviews of the Triller app. 3, Triller failed to meet its burden in prong 2, including failing to demonstrate a legally cognizable economic relationship, causation, and damages. Also, on January 12th, 2022, the court related the two actions, this one and that one. And on January 13th, Kavanaugh filed a 170.6 preemptory strike against Judge Helen Zirkin, the judge providing over the other case, and that was granted because it was timely filed. So this is now in front of a new judge, but they're all together. We go through the anti-Slapp prongs. The prong 1 means the prong 1's a burden that the defendant has to meet. And once the defendant meets that burden, it shifts to the plaintiff. The defendant, Klein, will meet that burden here, just like he did in the other case. And then it will shift to Kavanaugh to respond to this. And when he responds, we will cover it. We're not going to go through the legal standard because we've gone through it so many times before. And they're going to meet it. So there's no need to break it down. But I agree with them. I don't think there's any way these causes of action can stand because Klein didn't say anything outside of what Variety reported. And the other stuff that was said was hyperbole and mockery, which is also protected. So I don't know how we get to defamation on this. Kavanaugh cannot prove actual malice. As a public figure, he must prove by clear and convincing evidence the statements were made with actual malice, not meanness, legal standard actual malice. Therefore, he must prove defendants in fact entertained serious doubts as to the truth of the publication or acted with a high degree of awareness of its probable falsity. If the Variety article is still up, which it is, why would anyone doubt its truth? It hasn't come down. How do you prove that somebody should disbelieve that article when there's multiple articles about it and a verified, signed under penalty of perjury complaint? They also make this argument that I think is absolutely accurate. Kavanaugh cannot meet this burden because the verified complaint contained allegations made under oath. Sparr's post-settlement statements were hearsay and failed to demonstrate falsity. 3, Sparr's statement had no indicia of truth and appeared to be a prepared settlement statement. Yep. And 4, at no point in time has Kavanaugh supplied admissible evidence that Sparr's allegations were false. He made the allegations in a lawsuit. He said it. It doesn't matter if it's an actual Ponzi scheme or not. What matters is, did Sparr say that? If Sparr said it and it's not true, sue Sparr. Oh, but you can't because he said it in a lawsuit, and that's protected by litigation privilege. Kavanaugh can't prove special damages. We'll get to damages when we get to some of these additional exhibits. Conclusion: for the reasons above, this should be granted. I think there's a high probability here that it will be. Let's get to Ethan's declaration. So this is one of like 4 declarations attached. We're now on page 35 of 886. We'll be here till tomorrow. No, we won't. We're not going over all 800 of them. Ethan, TEI is a production company that takes 5%. Sorry, I make myself giggle. That creates online content, including the H3 podcast, which airs approximately 3 to 4 times a week on YouTube. I'm the owner of TEI and the host of the podcast. The podcast YouTube channel has over 3 million subs, and each episode receives millions of views. In the podcast, the cast and I discuss and provide our opinion on current events, YouTube, social media, influencers, and pop culture through bombastic and hyperbolic comedic criticism. The podcast enhances the bombastic and hyperbolic comedic criticism by utilizing viral sound bites, memes, various visual effects, music, video clips, and sketches. Below is a list of the podcast episodes that discuss Ryan Kavanaugh, Triller's social media app, and are referencing Kavanaugh's complaint. We're going to zoom through those because it's a whole link. It's a whole list of all of them. And yeah, it's all of the podcasts. Don't worry, they're all provided to the court on an external hard drive. The court has all of them. On April 17th, a Triller subsidiary broadcast a 4-hour boxing and music event titled Jake Paul versus Ben Askren. On April 22nd, the TI released a podcast that used 42 seconds out of the 4-hour broadcast to comment and criticize the broadcast main event. This resulted in Triller Fight Club 2 suing me, the company, wife, and the fashion company for copyright infringement on April 29th, 2021, after the initial lawsuit against me was dismissed by the Honorable Percy Anderson, whose sass will forever reign in infamy. We love him. Dismissed by the Honorable Judge Percy for improper joinder, Triller Fight Club 2 refiled its complaint alleging copyright infringement in the action entitled Triller Fight Club 2 versus TED Entertainment. On May 3rd, Triller publicized the lawsuit against me in a Reuters article. I didn't know that. I will have to pull this up at some point. The article also promoted Triller Fight Club's 2 settlement program. This settlement program was for third parties who watched the broadcast without authorization to avoid Triller Fight Club 2 suing them. Maybe Mike participated, and that's why he hasn't been resued. Oh no, I don't think so. I think the reason Mike was not resued is because they couldn't figure out who runs that YouTube channel. Therefore, cannot sue them. That's the individual that actually re-uploaded the entire broadcast. Let's see. A true and correct copy of the May 3rd article, authored by Rory Carroll, titled Exclusive Triller offers clemency for boxing fans who pirated Jack Paul. Did they really spell it wrong? No. Okay. That's just a typo. Jake Paul bout if they pay up. Available online and is attached down below. Sometime in the first half of May 2021, counsel for Triller, Novian, who represents Kavanaugh in the present action, and Triller in the other action, informed my then attorney Jeff Gant that Kavanaugh was the primary force behind the copyright action. Ms. Gant relayed Novian's statement to me. Prior to Novian revealing that Kavanaugh was the primary force behind the copyright action, I was completely unaware of Kavanaugh. I began researching Kavanaugh's connection to Triller. My research soon revealed a voluminous number of news articles reporting on Kavanaugh's checkered past. Below are some of the news articles I reviewed during my research. This is why I think the shit that I said was true. Here it is. And here's all the articles. This is what I relied on. These are the articles. This is what's being said. This is why I think what I said about Kavanaugh is true, because I was re-reporting what all of these other publications have said about Kavanaugh. All of these linked, all of them printed out below, which is why this is 800 plus pages long. But I will link the Variety article down below. Let me just pull that up so I can remember to link it. Oh, actually, let me give that. I'm just going to give that link to my mods so we can link it, because I forget to link it in half of these episodes and it's more helpful than not. So we'll link it in the description. More articles, more press, more rabbit hole. There's a full ass rabbit hole here about Kavanaugh. On May 14th, I was shocked by this, by the way. I was like, what? On May 14th, 2021, Triller Fight Club's counsel sent a letter to my then attorney, which demanded that I make false statements to the public to induce third parties to participate in the settlement program. Specifically, they demanded I state that I paid millions to settle. Don't worry, we're going to go through this letter too. It's attached. And Triller had embedded watermark technology unlike anything we have ever seen, without providing me any information about said watermark technology to provide any basis upon which to make such a statement. A true and correct copy is attached. So they tried to get Ethan to settle, and then tried to use Ethan to induce other people who might have watched the fight illicitly to go pay them on this website without granting them. I know attorney Tom covered this. I covered this. Others covered it. It granted them no agreement that they wouldn't sue them. It's like, here's my real name. Here's my IP address because I'm sure it tracked it. Speculation. I'm not sure. I would assume that it tracked the IP that the information was coming in from. Here's my name. Here's where I'm coming from. And here's my payment, affirming that I pirated your fight. So now you know where I'm at. Mhm. I considered Triller Fight Club's copyright action to be without merit and no different from my prior lawsuit, Haas v. Klein. The only difference was a power shade incoming in 3, 2, 1. Was a powerful media executive, Kavanaugh, and a large media company were behind the copyright action, while Haas was initiated by a YouTuber whose day job was delivering pizzas. Just the opportunity to just be like, bing. Due to Triller Fight Club's counsel's statements that Kavanaugh was the driving force behind the copyright action and what I discovered during my research of Kavanaugh, I drew the conclusion that Kavanaugh was responsible for Triller Fight Club 2's bad faith litigation tactics. As a result, I decided to publicly speak out about Kavanaugh and Triller on the podcast. Released podcast episodes stating Kavanaugh was behind the copyright action. It's my opinion that Kavanaugh looks like Harvey Weinstein, the Variety article, and Elon Sparr's June 6 verified complaint, stating that Triller misrepresented the comedian and actor Kevin Hart, the Kevin Hart of it all. The Kevin Hart of it all. The Triller misrepresented comedian actor Kevin Hart's presence on the Triller app. By the way, the judge brought it up in the other case and said, well, what's Kevin Hart on the app? No, Kevin Hart was not on the app. Kavanaugh's involvement in numerous bankruptcies of Relativity Media, various tech issues that people were experiencing with the Triller app. It's flipped. Various technical issues. It's flipped. My hyperbolic review mocking the Triller app and Kavanaugh, and positive and negative reviews of Triller. I did encourage viewers to try out the Triller app and leave an honest review. I stated, however, that viewers should not leave troll reviews. On July 13th, despite knowing I was represented by counsel, Kavanaugh's counsel emailed a letter directly to me, which they shouldn't have done, with the subject line, demand for retraction and correction of defamatory statements pursuant to California Civil Code 48A. The 7/13/21 letter failed to identify what statement Kavanaugh considered defamatory or how they were false. We'll get to that letter. It's attached. Out of an abundance of caution and in a demonstration of good faith, on July 15th, they produced a podcast episode that discussed that Sparr withdrew his verified complaint after it was submitted for filing, and the post-settlement statements of Mr. Sparr and Kavanaugh's representative. I also provided my opinion that I did not find Sparr's post-settlement statement to Variety particularly credible because the verified complaint was made under oath. Sparr's post-settlement statement to Variety was not made under oath. It seemed implausible that within a few hours of Sparr filing the complaint, that Sparr would suddenly describe Kavanaugh as a visionary thinker, which set forth in great detail Kavanaugh's fraudulent statements, financial mismanagement, and poor reputation. The explanation by Kavanaugh's representative that the complaint was filed by accident came across as completely implausible, and that Sparr never identified what information he was provided that made him suddenly characterize the Ponzi scheme as not accurate. This goes into other topics discussed on other podcasts. Same here with the Govern Yourself Accordingly podcast and what was discussed, and the different topics and the exhibits and timestamps if the court would like to take a look. This gets into Twitter and the tweeting about the Variety article. On July 11th, Kavanaugh sent me a DM via his Instagram account, which we're going to just get to the screenshot of, but it ended with the Govern Yourself Accordingly. After I discussed the 7/11/21 DM on the podcast, the phrase govern yourself accordingly became a meme, i.e. a piece of content that is used on a repeated basis to express a greater point regarding Kavanaugh's aggressive approach to litigation. A true and correct copy is included. We'll get there. This is the t-shirt jokes and the music album jokes that are also attached. These are the memes, which we'll get to. On September 9th, I made a tweet where I asked people to tell me what they thought of Kavanaugh. There were hundreds of responses. The vast majority of responses discussed my opinion that Kavanaugh bore a physical resemblance to Mr. Weinstein. This gets into the Content Court t-shirt, the parody website that's still up. This gets into Kavanaugh's, just Ethan's recitation under oath that Kavanaugh made these social media posts, which I'm sure will all be subpoenaed at some point if this continues forward, which it may not. They might not get to discovery, because if the anti-Slapp is granted, they're not going to get to discovery. It'll just get dismissed with prejudice. And then Kavanaugh will have to pay Klein's lawyer's fees. But if it gets to discovery, I don't think it will, which means we're never going to see the settlement agreement. But I mean, our curiosity aside. A true and correct copy of the screenshots are attached. True and correct copy of a lot of stuff is attached. In response to the present action, TEI released a series of podcast episodes. This talks about all the topics on the different podcast episodes, including Kavanaugh's war with Wikipedia. This gets into all of the different posts, what Reddit is. In paragraphs 19 and 52 of the complaint, Kavanaugh refers to my public dispute with Daniel Keemstar Keem. While I do not believe my dispute with Keemstar is relevant to the present action, I would like to clarify for the record, should the court believe it is relevant. Keemstar runs a drama channel on YouTube, i.e. a gossip channel. Several individuals in the YouTube community have been critical of how Keemstar uses his platform. In May 2020, I created a series of videos that express my criticism of Keemstar, mainly 1, that he exploits those suffering from mental illness and emotional crisis for the sake of content. 2, that he has repeatedly made baseless accusations that various individuals are P-words or engaged in SA. 3, that he has doxed, i.e. disclosed personal information such as phone numbers, addresses, personal email addresses, his enemies out of spite, which has led to swatting. We know what swatting is. 4, that he falsely accused me of defrauding those who financially supported me in my previous lawsuit, the Haas lawsuit. 5, his repeated attempts to intimidate me by threatening to report false stories about me. 6, his racist, homophobic, and misogynistic statements, including ridiculing victims of SA. 7, that he uses his platform to target his perceived enemies. 8, the precedent he set by targeting a content creator's sponsor on multiple accounts. And 9, falsely accusing an autistic child of sexually abusing the family dog. In a series, I commented how Keemstar's brand was ubiquitous with the G Fuel brand, and questioned why G Fuel would support an individual who engages in such conduct. Keemstar later claimed that it was his decision to terminate his business relationship with G Fuel, and then it includes links to all of those videos. They're also provided on the hard drive. It doesn't address the statements from the lawsuit, though. Y'all know the statements that were made in the lawsuit about Keem. Y'all can put it in the chat. You remember. In paragraph 53 of the complaint, Kavanaugh refers to my public dispute with Trisha Paytas in so many lawsuits. While I do not believe the dispute is relevant, I would like to clarify the record should the court believe it's relevant. Paytas is an extremely controversial figure on the internet and has received a tremendous amount of criticism on the internet for her insensitive behavior and statements. For a period of time, Paytas was my co-host for a podcast series entitled Frenemies. Doesn't Frenemies feel like it was 700 years ago and we all lived in a different world? It feels like the world was so different when Frenemies existed. It's like it's a different timeline at this point. During some Frenemies episodes, Paytas would lash out at me, my wife, and the crew of the podcast. When our friendship fell apart, Paytas made countless videos and social media posts that continued with these attacks. When I sought to clarify the record, Paytas released even more videos and social media posts claiming she was the victim of online harassment. Given Paytas's attacks, I became critical of her and discussed, inter alia, 1, her demonstrably false allegations of SA against her, now deceased high school teacher. 2, her statement that she bribed a rabbi to convert her to Judaism. 3, claiming to be a Wiccan a few weeks after claiming to have converted to Judaism. 4, how she marginalized the LGBTQ community despite claiming to be non-binary. Why is my nose stuffy all of a sudden? 5, how she minimized those with mental illness despite self-diagnosing herself with a mental illness, with one mental illness, multiple. I think we can say with mental illnesses. Mo- eh. 6, how she claimed I was not, quote, I was not a, quote, real Jew and degraded me for suffering from Tourette's syndrome. And 7, how she why I'm never going to be able to say fetishizes, how she fetish, nope. Emily tried to say fetishizes multiple times. How she that various minority groups, a true and correct copy of the June 9th podcast episode entitled regarding Trisha quitting frenemies is available at the link and on the hard drive to the court. The court is going to be like, what the fuck is happening? I don't care. A law clerk somewhere is going to be living for it. Next declaration of Jeff Grant in support of defendant's special motion to strike. This is an attorney declaration that goes through the exhibits and what letters Novian and Novian sent so that they can be the letters can be authenticated in true and correct copies. Zoom. The next one is this attorney's declaration saying that the lawsuit stuff is attached, that the lawsuit stuff is true and accurate, what happened with the law, what happened with the statements, what happened in the previous cases, that those are all true and correct. And again, saying that Novian informed me that Kavanaugh was the main force behind the first copyright action, second copyright action, and the threatened tortious interference and defamatory actions or defamation actions. Specifically, Novian said that Kavanaugh was contacting him, quote, every hour on the hour to check on the status of the second copyright action and the threatened tortious interference and defamation actions. I did not take this comment literally, but I understood Mr. Novian to be commenting to me that Mr. Kavanaugh was frequently calling about the matter. Additionally, defendant's prior counsel, Jeff Gant, informed me that Mr. Gant had also had communications with Mr. Novian, where Novian told him that Kavanaugh was the driving force behind the first copyright action and second copyright action. Trillery shit attached. Stuff being dismissed. The uniform dispute resolution action about the does Ryan Kavanaugh look like HarveyWeinstein.com website filed twice. This is about the previous lawsuit that was dismissed, the other LA suit. And this is just saying these are all the transcripts and everything that happened in that suit. So if you, for some light reading, Your Honor, I found this declaration fascinating. Declaration of Eric Gardner. Eric Gardner is a reporter. If Twitter, there's Twitter action. Go follow Eric Gardner on Twitter. But fascinating. Eric Gardner wrote an article that I shared that was great, and we'll talk about it. I was going to start keep reading, Emily. Keep reading. Keep reading. There is so much cat hair on my desk right now. Keep reading, Emily. I am currently the founding partner and national correspondent for Puck News from January 2006 until January 21st, 2022. I worked for The Hollywood Reporter. During that time, I held, among others, the title of senior staff writer, contributing editor, and editor at large. My responsibilities at THR included serving as editor of THR's EXQ section, which focuses on legal and business issues affecting the media and entertainment industry. Ryan Kavanaugh is well known in the entertainment industry. During my tenure at THR, I wrote several articles about him. Below are some of the articles. True and correct put out is attached, but this included the article that broke down how the court filing system works. This was this November 30th, 2021 article entitled Ryan Kavanaugh's New Mindbender, When is a Lawsuit Not a Lawsuit? This is a great article. I shared it on Twitter, and I'll put it in the description here as well, because it is a great breakdown. And I shared it before because it did a fantastic job of breaking down that gap in time when suits can be filed and overlap. So, the Los Angeles Superior Court has a media portal that enables members of the media to receive instantaneous access to all LA Superior Court filings. Orange County does too, by the way. Using the media portal, I have personally reviewed complaints that were on the portal that were dated the same day as I reviewed them on the portal, but there was no indication on the complaint that the matter had been given a case number or assigned to a judge. A complaint accessed through the portal that has been filed but is still processing will have an unfiled watermark on it. And so it talks about that and that article and breaks that down of how that ended up in the Variety article. And then these are the other articles that he wrote. He's like, these are the things I reported. Here's true and correct copies. A few hours after I published my article, Exhibit 97, I was contacted by Mr. Kavanaugh's representative, Howard Bragman, who complained that no lawsuit had been filed and that my article defamed him by quoting from Mr. Sparr's complaint. I later discovered that Mr. Kavanaugh and Mr. Sparr apparently withdrew their lawsuits prior to these lawsuits being given a case number and assigned a judge by the LA Superior Court system. I updated my article to state that the parties had apparently settled the dispute. Mr. Kavanaugh did not sue me or the Hollywood Reporter, and as far as I'm aware, he did not sue Variety or The Wrap. And now, an attorney, these things are true. We're going to get into some deep money shit. I am not going to get into all of it. These are SEC filings that report some of Triller's financials. So when Triller is saying in the past lawsuit and this lawsuit that they have had substantial financial losses, we're just going to look at what this attorney is presenting from an SEC filing and how they've interpreted it. Paragraph 64 of this complaint alleges that because of these allegations and the phony one-star reviews Klein's foot soldiers have baselessly posted about the Triller application, Mr. Kavanaugh has incurred substantial financial losses estimated to be in the tens of millions of dollars. In other words, plaintiff Kavanaugh is alleging defendants' alleged defamatory statements and purported incitement of viewers to leave one-star reviews damage the profits and goodwills of the company owned by Kavanaugh, Triller. Well, let's look at the SEC filings. On pages 195 through 197, the February 22nd, 2022 Form S4 provides pro forma results of operations and comprehensive loss for Triller. This is because a company, Sea Change International, filed the form with the SEC because they are looking to merge with Triller Holding Company, the parent company, the overall company of all these other companies. So let's see what was reported to the Securities and Exchange Commission with regard to the financial position of Triller. Shall we? Do y'all want to take a guess in the chat the way this is going to go? Is this going to support the claim that there have been financial damages, or is this not going to support the claim? I wonder what you will think. From 2022, that doesn't make sense. From 2022 through the end of 2021. I don't know how that makes sense because we're just now in 2022 through the end of 2021. Triller's revenue increased from $66,224,000 to $81 million, i.e. an increase of $15 million and 24%. But again, this, I don't know. It has tables and defined terms. It is also attached and we can look. They might have flipped the numbers on this because this might have been, I don't know. The from 2022 through the end of 2021 doesn't make sense unless it's just 1 month. Maybe it is just the 1 month. From 2020 to 2021, Triller operated at a net loss, which increased from $75 million in 2020 to $810 million in 2021, an increase of $735 million and 976%. The increase in net losses are primarily attributable to one, cost of revenues, and two, general and administrative. So they didn't leave it. They didn't put anything in there about this damage, which is interesting. The 2022 Form S4 defines cost of revenues as primarily production costs related to more events, an increase to compensation expenses, including stock compensation, related to cost of revenues, higher musical talent and licensing fees, an increase in IT-related costs, and the impact of acquisitions. Fair. The form defines general and administrative expenses as primarily a $380 million increase in stock-based compensation expense and compensation expense allocated to G&A. It then talks about the general and administrative expenses increasing from 30 million to 418 million in 2021. Okay. So Pam Marshall's like, I want to see the S4. Pam, I will put the link in the description for you. Hold on. We're going to get the description. So if you guys want to go look at the S4, you can. I would love to hear your thoughts on it. It is publicly available and it's also attached here. So I will put it in the description. I will also put it in the chat. So if anybody wants to look, it's a public filing. I would love to hear your thoughts on it if you have thoughts, because I'm sure you have questions. This is not my jam at all. Let's see. We went through that. Let's see. In note 11, entitled Goodwill and Intangible Assets, remember they're saying goodwill was damaged. In note 11, entitled Goodwill and Intangible Assets, on pages F92 through F93, the Form S4 sets forth the value of Triller's trademarks and trade name and goodwill from December 31st, 2020 to December 31st, 2021. The net carrying value of Triller's trademarks and trade increased from $439,000 to $7.6 million, an increase of 1,638%. From December 31st, 2020 to December 31st, 2021, the goodwill acquired by Triller increased from 10 million to 183 million, an increase of 173 million, and 1,816%, like 1.8 million percent. What? The form also noted that there was no goodwill impairment. So again, if you're arguing in the lawsuit that your goodwill has been damaged, but you're telling the SEC during the same period of time that it hasn't, there are questions. And how do you override that? Okay, we need to get to some of these exhibits. And for that, I'm going to have to zoom. So I'm not going to zoom at you, but we've got to get down to like page 400 and something to get to the exhibits that I wanted to show, which is the letters from the lawyers. Let us get to the lawyer letters as my poor system struggles to keep up as we're scrolling through hundreds and hundreds of pages. So I will, as we finish these exhibits, get to questions after that. And I'm going to pull up a few super chats. Well, my computer is trying to catch up. Oh, here we go. Ha. We got to exactly where I wanted to be. I'm so excited. Luke, thank you for the super chat. Malonards. Thank you, Luke. I appreciate that. Also, can I tell you what? StreamYard has added a new feature where I can save these for later so I can pull them up on screen instead of just reading them out. And I am so freaking excited by that. Thank you, Elise, saying law nerds plus gossip plus serious discussions of all the things plus awesome days for all, even unintentional, equals amazing week for all. Thank you so much, Elise. Skylar said, making surf and turf loaded baked potatoes. Now you're going to make me hungry. Gin and hibiscus water with jalapeno popper, egg rolls. Let's ride. That sounds delicious. I want to eat all of that. That sounds amazing. All right. Let us get back to the exhibits. We need to get to 102. Hold on. We got to back up. We got to back up just a little. We're now on page 619. We got to zoom just a little bit. There are so, wait, hey, it's me. I need to update that thumbnail. I can make a better thumbnail. But look, it's us. Oh, there's me too. Lawyer reacts. Let's talk. I love it. Ooh, that's me too. Why am I in here? I'm curious. Is that the up next? I love that the up next in the Triller recommended is me. I didn't know that was there. I'm a little too excited about that. Sorry, y'all. Look, it's the little wins on YouTube. We've been trying to hit 200K for like a million years. So it's the small wins I'm very excited about. You know, every time we see ourselves in a lawsuit, we're just like, oh, look, mom, we've made it. Okay, we've got to get to these lawyers back and forth because it is, if you ever want to know what it's like to work as a lawyer, these letters are going to exemplify it. Once we get to the other one, my computer is like, nope. I'm going to have to refresh. Damn it. Okay, we're going to pull up the rest of the super chats while this is refreshing itself on page 586. Hold on. We're almost there. There are so many pages, y'all. It's so much. Thank you for the super chat for the book fair. It is much appreciated. What's the book? So the book was on a members only live stream. It is also on my Amazon. It is called The Sad Little Fact. It is the greatest book ever. I loved it. It is very fun. For the demonetization fund for Puseta. I mean, I said the things. It's educational. It's in a lawsuit. We're not being scandalous, YouTube. I don't know if we yellowed ourselves or not, but we probably are under review. I'm sure y'all will. We're probably under review. Whatever, it happens. But we're probably under review. It happens. Thank you for the catnip tip. Guess who treated a super fiance to a bottle of salted caramel whiskey today? Yay! I hope you thought it was delicious, Ashley. Let me know. Dumb question. So, never a dumb question. We love a question. Also, I realize that a lot of you have not been able to watch every single breakdown of every single thing that we've done. So, there are not dumb questions. Always ask. And thank you for the super chat so I see it. So Anti-Slapp reimburses lawyers' fees, but what about taxpayer dollars for the judge, etc., and Ethan's stress? He's been very stressed. No. It reduces the amount of court time because it stops the litigation, but it does not award anything other than the legal fees. It does not award things like pain and suffering, etc., etc. If Ethan wanted to sue Ryan Kavanaugh for something like intentional infliction of emotional distress, or for being a vexatious litigant, or for harassing litigation, he could choose to do that and pursue some of those other remedies under the law. The anti-slapp is where the defendant stops the lawsuit that they are being sued for and gets their attorney's fees back and stops it. It doesn't mean they can't choose to sue for those other types of damages down the road. Now, I'm not saying whether they should or shouldn't here. I'm just saying that that is one of the remedies. All right, let me try to refresh this document that is just like, hey, what we're not going to do is continue to pull things up because it just froze in the middle. So we can get to the rest of these. Let us just see if our computer can keep up. It's been doing a pretty good job. This is quite a lot of stuff. I just need to get back into like the 600s. So let me as I scroll, let me get to a few more. Can I do it? Nope, that takes way too long. We're professionals here. Thank you all for hanging with me as we do that. We'll just be another minute. Thank you for all you do with keeping us informed. I love doing it. I love keeping you informed. You are welcome. Can you break down the $900 million McFlurry lawsuit? I have been wanting to talk about it. I just have not had time, but it has been on my list. I don't know. I feel like I'm very short tonight in my screen. Like my chair is lower, which is probably because my kids have been in here playing with my chair. I feel like I feel like maybe I've just gotten tired. I feel like I've gotten low. Shorty got them apple bottom jeans. Have you guys seen TikTok, the Beach Boys version of apple bottom jeans? It's freaking impressive. It really is. It really is quite stunning. Um, I'm gonna have to duet somebody's just so I can. Oh Jesus! I have just clicked myself out of this. Why is it so hard to get to page 600 of this freaking anti-slap? It's a great anti-slap. It just has a lot of exhibits, like a lot. They're needed exhibits. I'm not knocking the exhibit. Thank God in heaven we are here. Oh, the force is with us. We have found where we needed to be. I'm going to start singing Alleluia. No, I won't because I would butcher it, but we got it, you all. We got it. We got it. We got it. Exhibit 102. From Novian and Novian to lawyers. May 14th. Triller Fight Club versus H3 podcast. Oh, my mouth is so dry. Look, y'all. The Invisalign is real. The Invisalign is real. And it's making my mouth dry. Also, I've been talking for, 2.5 hours. Apologies. First, I ask again, will you agree to accept service on behalf of the H3 podcast or waive service of process? If not, I will arrange to have Ethan and Hila personally served. Second, I am familiar with the Haas case. Your reliance on it is misplaced. As you will see in the below still image taken from the H3 podcast episode 244, your client made available to the public the URL for a free, unlicensed copy of the entire broadcast containing no supplemental commentary or other attempt at transformation. This is markedly different from the Haas case. So they are trying to argue that the use of the other channel with the unlisted YouTube video is what caused the issue. That is now the problem. It's not the commentary on the podcast, it's the uploading it to the unlisted channel as an unlisted video that is the issue. When any of your clients' million-plus viewers typed that link into their web browser and hit play, those viewers committed copyright infringement. Depending on who uploaded the pirated video, this exposes your client to liability for either direct or contributory copyright infringement. Should have just used Mike. I do not see fair use as being a factor, even if your client's discussion of the fight was fair use. So they are trying to go after that. As you are surely aware, the complaint against the H3 podcast asserts causes of action for inter alia violation of the Federal Communications Act. These causes of action provide for strict liability in connection with your client's supposed fair use defense will be of no avail. Your note that Triller seeks actual damages. You note that Triller seeks actual damages. It does, which the law permits. In light of the foregoing, we hereby reject your client's offer to settle this matter for a payment of $25,000 and counter propose settling this matter for your client's payment of $900,000, an agreement to make the following statement. We are pleased to announce that we've reached a settlement with Triller Fight Club. As a result of us pirating the event, Triller surprisingly has embedded watermark technology, unlike anything we've seen to date. We had to pay millions to settle in order to avoid $50 million or more in potential liability. We encourage anyone who pirated the event to take Triller's amnesty offer very seriously and pay the $50 before what happened to us happens to you. Triller is incredibly serious about this, and we do believe they will find most, if not all, people who pirated. They can't find Mike. They can't find the people they already sued. Those lawsuits, a lot of those lawsuits have been dismissed because they can't even find the people they already sued. They can't even find the people they already sued. They're going to spend so much in legal fees. I don't think they give a fuck, though. Finally, it has come to my attention that your client has been making YouTube videos in which he discusses the contents of these ongoing settlement discussions. For example, in this video your client posted to YouTube beginning at about 34 minutes, if your client continues to publicly discuss the contents of our ongoing settlement discussions, we will cease negotiating with you and litigate this through the courts. Go ahead. Go ahead. Because this settlement statement is such a load of bullshit. But also, in light of this, you can see where Ethan's looking, like this happened in May, right? So you can see where Ethan's looking at the settlement statement made by Kavanaugh's former business owner going, I have been to the circus. I have seen the animals. I have seen how this goes behind the scenes. And I know the statement that they want me to release is false. So why should I believe that that statement made by the business partner is true when there is a sworn under penalty of perjury statement? Why would I believe it? After seeing this, would you believe it? You'd be like, oh, they want you to make whatever. They want you to say whatever. And maybe somebody would to avoid a lawsuit, but Ethan's not going to. I can understand why you'd be like, no, fuck this. This is a game that I am not playing. This is all a giant load of bullshit. It's weird to me how pixelated their like this is so clear, but their name is super pixelated on this. It's so weird. Maybe it's the way that it's scanned, but it feels like they're like using the thumbnail image of their own logo because it is so freaking pixelated. Maybe that's just me being picky, but it looks weird. Next exhibit from, well, this one did too. Strange. Maybe it's the scanning system. Maybe not. Selena said 900,000 is not millions, just saying accurate. That's an accurate statement of fact. $900,000 is not in fact millions. As you know, this was from June 29th. So after that May letter, there might have been more correspondence in between. I don't know. As you know, we are counsel for everybody. We are writing to you to schedule a meet and confer regarding 2 motions our clients intend to file in response to the FAQ filed by Triller Fight Club. 1, a motion to dismiss. 2, a slap, anti-slap. On June 1st, in our June 1st letter, we explained in extensive detail why the Honorable Percy Anderson is a baller shot caller and we loves him the most. Why Percy Anderson was right about everything. The Honorable Percy Anderson was completely correct in expressing serious concerns regarding the adequacy of Triller's compliance with its pre-suit investigation obligations under Federal Rule of Civil Procedure 11. They didn't have dates. Our June 1st letter unequivocally demonstrated that Triller did violate its obligations under FRCP 11 because each and every claim in the FAQ was fatally defective as a matter of law. Additionally, remember Percy Anderson? Percy Anderson was like, you have to have a well-pled complaint. Additionally, we provided you with an extensive amount of facts that further demonstrated that each and every claim in the FAQ was devoid of merit and that the FAQ contained demonstrably false allegations that Triller could have discovered if it had complied with its discovery obligations. We also warned you cease engaging in FRCP Rule 11 violations or you would leave our clients no choice but to seek sanctions. In your June 8th letter, Triller did not heed our warning and continued to demonstrate its bad faith. The June 8th letter advanced a series of untethered and untenable arguments. By the way, this is what lawyer life looks like. It doesn't look like TV. It looks like writing shitty fuck you letters back and forth to other people via email. But I like the way that Ethan's lawyers write. The letter advances a series of untethered, I need to start using untethered instead of unmoored, untethered and untenable arguments that were either completely inapposite or divorced from the law and facts. Even more shocking was that Triller failed to address, let alone refute, the vast majority of the points in our 6-1-21 letter. Most egregiously, Thriller had the chutzpah. I love this email. I really do enjoy this email. Triller had the chutzpah to claim that we were in violation of our ethical responsibilities, despite Triller itself making completely frivolous arguments and intentionally misrepresenting the record and the law. The time has come for Triller to decide, will it continue to engage in bad faith by making demonstrably false statements of law and fact, or will it come to terms with reality and concede it does not and cannot allege a viable claim against our clients? Our clients are no longer inclined to play whack-a-mole to refute each and every one of Triller's desperate, deceptive, and even delusional arguments. Nor will we point out each and every one of the countless instances where Triller effectively conceded that its fact lacks merits by failing to address, let alone refute, the majority of points raised in our 6-1-21 letter. We will, however, demonstrate how the 6-8-21 letter, like Triller's prior pleadings and statements, was rife with materially false statements of fact and law. We strongly advise Triller to read this letter closely, including the authorities cited in this letter. In their generosity, our clients are providing Triller with two options to avoid continuing to violate Rule 11 and California Rules of Professional Conduct 3.3. First, Triller can submit to us a proposed Second Amendment complaint that properly pleads viable claims, assuming that is possible, which we believe it is not. Assuming you have a claim, could you please fucking state a claim upon which relief should be granted? Could you please state a claim upon which relief should be granted? Please. Pretty please. Bring your sack and make it better. But no. Second, Triller can dismiss the fact with prejudice. You can pound sand also. Be advised, our clients will not tolerate any further bad faith arguments, nor will they stipulate to another abusive and harassing complaint that persists in failing to adequately plead viable claims. If Triller does not heed this final warning, our clients will have no choice but to file their motion to dismiss and anti-slapp and seek their attorney's fees. The grounds for both motions are set forth in detail below. We've already gone through the anti-slapp that was filed in the California case. The motion to dismiss will be coming up next month in the federal case, and we'll jump back into that case, the copyright case, as it comes closer to hearing not next month, in April. So this goes through all of the anti-slapp stuff. I like that they cited Merriam-Webster. They went through that motion that we already went through. So we're going to get to the end of this because they laid out their entire motion here. It's like, here is our motion. Stop it. You are going to lose, which they did. They did lose this motion. This is not going to go well for you. And it did not. This letter was correct. Are we done yet? No, we're not done yet. Oh, fascinating. Here we go. On May 3rd, online commentators began discussing the podcast was sued by Triller and even focused on where the reference video appeared in the 4/22/21 podcast, footnote 22. Until that point, there was little, if any, discussion online about the Film Daily FAC and its allegations against the podcast. We covered it because it was funny. When TEI became aware of the fact that the online community was discussing Mr. St. Clair's statements, it checked the analytics of the reference video and saw a bump in views. As such, on May 3rd, they changed the reference video status from unlisted to private to prevent further views. The YouTube analytics are below. So they're saying that the Sinclair individual talked about the views. Here, let me back up real quick. The screenshot that we previously provided to you undeniably demonstrated that one, the reference video had only 51 unique viewers for a total of 65 views, and two, had an average watch time of 57 seconds. In other words, the reference video received less than 0.0065% of the views of the 422 podcast. Additionally, if we were to calculate the purported lost revenue of $49 for each unique viewer of the reference video, the total amount of speculative loss would be $2,549. Most notable, 45 of those views came on May 3rd, and hardly any occurred from when the 422 podcast aired until that date. The reason why May 3rd is important is that this was the same day that Triller's so-called head of privacy, Mr. Matt Sinclair, made a statement to Reuters for the May 3rd article entitled "Exclusive: Triller offers clemency to boxing fans who pirated Jake Paul bout if they pay up." Specifically, Mr. Sinclair stated the fines are calculated at $150,000 per instance. So far, H3 and other sites who rebroadcast the event to many people, the potential damages are large. Mr. St. Clair went on to say that it will pursue the full $150,000 penalty per person per instance of anyone who doesn't do the right thing and pay before the deadline. So because that article came out, they said that the day the article came out, the views spiked to like 50 unique viewers. Okay. Thus, if anyone is to blame for driving up viewers and views for the reference video, it is Triller and its entirely inept head of privacy, Mr. St. Clair. Due to their completely baseless, reprehensible, and irresponsible public statements, Triller and Mr. St. Clair created a Streisand effect where people suddenly became curious about the reference video. Until that point, virtually no one was interested in seeing the reference video, which again, this, I imagine, what is this, 0 to 15? This is when they were filming the podcast, or would have been around when they were filming the podcast. And that is what? 10, not even 10 views. Sorry, getting back to head of security, Mr. Sinclair. Until that point, virtually no one was interested in seeing the reference video. What emphasizes that people came for mere curiosity is that the average viewer only watched 57 seconds of the reference video, which consisted solely of the ring announcer Michael Buffer making introductions. Simply put, Triller's argument that the 42221 podcast did not make fair use of the broadcast through the reference video is patently meritless. Our client have absolutely no apprehension about stridently defending fair use in general and their fair use of the broadcast in particular. Triller will pay our client's attorney's fees, and they will in the California action. This goes on to talk about some of the other actions. And about why the claims are going to fail. It continues to be a you're wrong, you're wrong, you're wrong. These are all the ways we think that you will lose. We're still going. We're still going. Shockingly, in your 6/8/21 letter, Triller argues that pointing out this demonstrably false allegation misses the point. But that is exactly the point. Triller has repeatedly made false allegations about our clients in its pleadings to the court in violation of FRCP Rule 11B and California Rule of Professional Conduct 3.3. Further, contrary to Triller's preposterous assertion, our 6/1/21 letter explicitly denied our clients monetization, monetize their purported unlawful actions, such as generating advertising revenue. Our letter explicitly told you that the reference video was not monetized because one, the SoundLab channel is not eligible for monetization, and two, TEI would not monetize the channel even if it were eligible. Either Triller is materially misrepresenting the contents of our letter or failed to read it all together. Under no circumstance can Triller meet the direct financial interest requirement. The reference video was not and could not be monetized, and therefore there is no financial benefit received from the reference video by our clients, and the argument to the contrary is either based on rank and unsupported speculation or made in bad faith. In sum, Triller's vicarious copyright infringement claim is equally bizarre and meritless as each and every other claim in Triller's FAQ. Meet and confer. We are utterly appalled by Triller repeatedly making false statements of law and fact in its pleadings and correspondence. Triller has effectively made it our client's responsibility to educate Triller, not only on the law and facts concerning each of its claims, but how to draft a well-pleaded complaint in the first instance. Instead of recognizing our client's generosity and gracefully exiting stage left, Triller continues to demonstrate its bad faith by responding with even more demonstrably false statements of law and fact. There is absolutely no excuse for this, and we demand it end immediately. It's just go. Just lay down. Just go. At this stage, it is nearly impossible for us to conceive how a second amended complaint, which would be Triller's fifth opportunity to draft a complaint regarding the broadcast and fourth against our clients, could possibly cure the fatal defects of each and every claim in the fact, as we have explained above. In a gesture of good faith, our clients are willing to review any proposed second amended complaint to see if Triller can actually plead a single viable claim. Particularly one that does not make demonstrably false allegations. While our clients are not hopeful that Triller could cure such defects, they are willing to provide Triller that opportunity. If Triller is somehow able to cure these fatal defects, which we do not believe it can, our clients would be willing to stipulate to the filing of a second amended complaint. Please provide it. Be advised if Triller continues to make false statements of law and facts in its pleadings, the correspondence, or propose other fatally defective complaint, our client's position is that Triller has refused to meet and confer in good faith, and we will file their motion to dismiss an anti-Slapp motion. If Triller insists on using the judicial process and the press for intimidation, our clients will use them for vindication. Govern yourselves and your client accordingly, or face the consequences. Govern yourselves accordingly. This letter does not constitute a complete statement of all our clients' rights, defenses, contentions, legal theories, or facts in support thereof. Nothing stated herein is intended, nor shall it constitute a waiver or relinquishment of any of our clients' rights, defenses, or remedies, whether legal or equitable. All of the above are hereby expressly reserved. But wait, there's more. Exhibits. These are exhibits to that letter with the smackdown. I updated this thumbnail. I did. I've updated some of my thumbnails. I think have gotten better. I don't know. I feel like they've gotten better. I need to go back and update that one. This is all of the comments. This just doesn't want to say hello. No, we gave you plenty of time to populate. Where are we? This is another exhibit attached to that letter of playlists. It looks like Kevin Hart. We don't need these exhibits. I'm going to zoom to the next exhibit. The next letter. As you know, this firm is counsel to Triller Fight Club, and Ryan Kavanaugh. As you also know, this is from July 13th. Following defendants videotaped and publicly disseminated admission that they bootlegged or pirated certain copyrighted materials belonging to Fight Club filed a lawsuit against defendants. It has recently come to our attention, in addition to violating Fight Club's copyrights, defendants have been publishing false and defamatory statements that Triller is and Mr. Kavanaugh runs a Ponzi scheme. Again, it misrepresents the facts. No one ever said that Triller's a Ponzi scheme. People said that Triller is flipped. People said that Ryan Kavanaugh ran a Ponzi scheme based on the article in Variety, but that was referencing to Relativity Media, not to Triller. Just the basic facts, please. I feel like I've read this more than Triller's attorneys have at this point, and I'm exhausted by it. I'm sure they're charging much more than I am making in AdSense revenue, but I like my path better. and that defendants are engaged in a conspiracy to cause their rabid fans, known as foot soldiers, to go to war with Triller and Mr. Kavanaugh by parroting those same false and defamatory statements on various platforms, including but not limited to Instagram, Twitter, the Apple App Store, and the Google Play Store. This lawsuit failed. Defendants' false and defamatory statements intentionally and maliciously cast Mr. Kavanaugh in a false light by giving the impression that Mr. Kavanaugh currently runs a Ponzi scheme. No, it said that his former business partner accused him of running a Ponzi scheme. It is different. Indeed, not only do defendants fail to mention the retraction as noted above, but defendants also presented depictions of the Variety article in which the font was distorted to give the false and defamatory impression that the headline of the Variety article reads, "Ryan Kavanaugh running a Ponzi scheme." So this is that letter that they talked about earlier, that it's like, these things are defamatory, but it doesn't say that they're defamatory, and then it lists the retraction, but doesn't say anything else. You can't read the whole thing. See, it says Ryan Kavanaugh running a Ponzi scheme. You just have to I'm trying to hold my hand to the screen like you can see it. You just have to block out the accused by ex-partner part. You just have to ignore that exists. Oh, man. The thousands of comments and messages Mr. Kavanaugh has received since defendants made their false and defamatory statements claiming that Mr. Kavanaugh runs a Ponzi scheme made clear that defendants succeeded in misleading the public. For example, are these Instagram DMs? Instagram user Lex says, being a little baby about some people on the internet. I heard you were running a Ponzi scheme. Also, guess what? I'm BTS Army. And this is old ass news and irrelevant, you boomer. They're so mean. It's so mean. Called a boomer. Ain't you the dude that runs Ponzi schemes? From so y'all, now you have a chance. Your DMs might pop up. We've got some other DMs. We've got more Ryan Kavanaugh DMs. But wait, there's more. In addition, defendants display disparaging reviews that they themselves wrote for Triller's for its self-named app, and encourage their foot soldiers to leave similar reviews for the app and to send messages and leave comments for Mr. Kavanaugh. I don't think they ever said leave messages for Ryan Kavanaugh. I've never seen that. And yes, they are in fact trolling themselves at this point, I think. Yes. For example, in May 2021, Reddit user Conversation Actually 77 posted to the H3 subreddit, "Take down Triller. Let's all rate Triller a 1 star on the App Store for being greedy little fucks." Or on July 2nd, 2021, Reddit user To Poke Us Too posted on the H3 subreddit, "Foot soldiers, time to bank down Triller app, called by the king himself." There is no king. No one's royalty. On or about July 8th, Reddit user Don't Blame Meme 13, that's a clever name, posted on the H3 subreddit, "Foot soldiers assemble. Tank the Triller app. We can do better than this." You can't sue people for what was fucking said on Reddit, but this lawsuit already lost. I just enjoy the pictures. Because it's even got the article. Hold on, I'm trying to make this bigger. It's even got the article framed. Oh, and this all ended up in that lawsuit. These did not end up in that lawsuit. Since defendants published the above list of videos, defendants and their foot soldiers have left thousands of reviews. I don't ever agree with telling someone to unalive themselves. I think it's a problem. I don't think it's okay to ever send that to anyone, ever. But I also don't know how, fuck you, die, CUNT, KYS. I hope your mom gets hit by a bus. Well, actually, I hope she's already taking a dirt nap. I don't know how this ties into H3 at all. This is such a leaping assumption. This one talks about a Ponzi scheme, so I guess they're trying to target it there, but I don't know how they're relating any of these back to Ethan. Another Novian letter from July 14th. Demand to cease demand to immediately cease and desist unlawful conduct. As you know, this firm is counsel to Triller Fight Club, Ryan Kavanaugh. Do you remember that Novian and Novian is the law firm that filed as plaintiffs under the wrong Triller company and had to refile the lawsuit because they filed it under the wrong Triller Fight Club entity? I remember. I haven't forgotten. I will not forget. That I will not forget. As you know, this firm is counsel to all the people. As you know, Ethan, Ela, and Ted Entertainment videotaped and publicly disseminated admission that they bootlegged and pirated certain copyrighted materials. And this just, as we explained in our letter dated July 13th, this is the next fucking day. As we explained in our letter dated July 13th, it has recently come to our attention that in addition to violating Fight Club's copyrights, defendants have been publishing false and defamatory statements that Triller is and Mr. Kavanaugh runs a Ponzi scheme. You know how I feel about that. In light of the foregoing, our clients hereby demand that defendants immediately cease and desist their unlawful conduct, including by removing all episodes, comments, YouTube videos, Reddit posts, Instagram posts, or other such damaging statements, just whatever might be damaging, maybe. Suggestions and other content absent defendants' immediate compliance with our client's demand on Friday, July 16th, we will file the confidential draft complaint enclosed herein. Please confirm. We're going to file this lawsuit that then goes on to lose. And we all know this lawsuit. This is not the defamation lawsuit. This is the one that was already dismissed with prejudice. That has all the pictures in it. At least they got a heads up so they could laugh at it. So we've gone through that lawsuit plenty. We've gone through the First Amendment complaint plenty. Let me see. There's other photos that I wanted to get to before we go through their shitty First Amendment complaint that didn't do any better than the other one. Exhibit 107 is literally we're going through court documents to get to the rest of the exhibits that I wanted to show you guys before we finish up with questions and get rolling. I knew this one was going to be long, but there are some other fun things in here that I hadn't seen, including the video, the album cover, the parody album covers and stuff. This is all transcripts. Where are the parody album covers? I forget what page they were on. Oh no, I accidentally closed it. Hold on. I'm going to look and see what page they're on the iPad because it's going to be way easier to do it this way. And then we will get there. Let's see. Where are all the parody album covers? It is so many exhibits, y'all. And I should have made note of the pages earlier and didn't even think of it because I didn't think of how difficult it would be. At least on the iPad, I get thumbnails, how difficult it would be to scroll through these without thumbnail images on the website. Where in the world are they? Because we want to get to the screenshots of the DMs, even though I know Ethan has shared that already and you guys have probably already seen it. But where are all the album covers? Aha. Page 766 is where we're headed, folks. Let's see. Why can I just control find page 766? Can I control F myself? Am I wearing my, I am wearing my control F myself today. I can control F myself to page 766. Hopefully. That didn't take me to page 766. Why? Why not? Oh my God, my computer is so angry with me. Take me to page 766. Oh, because it's not noted as page 766. Hold on. What exhibit number is it? 111. We should be able to do it that way. Sorry, y'all. Technology is, well, kicking my ass today, frankly. Exhibit 111 coming up. Fingers crossed. Oh my God, there are 236 examples of 111. No. We're just gonna keep going and hope when we get to the bottom of them that that it will be actually Exhibit 111. Oh my god. Y'all, it's so many pages. All right, we're on page 500. This is not working well. I'm sorry. I never deal with documents of this length, and it is it is a lot. And I don't think I can just jump to it at the bottom because then it buffers. All right, we're at 6:30. See? Ugh. It is killing me. Hold on. Let me see if I pull up a different if I pull up my other note program, if it'll do it better. Cuz this in the G drive is literally do you see? It's killing me tonight. Let's see if I can pull it up the other way and do it better. Fingers crossed, everybody. We're trying new things. We're almost there. We're almost there. Let's go to share screen and see how this goes. Fingers crossed. Fingers crossed. Fingers crossed. You guys are like typing the page number at the bottom. It will not work in G Drive. It will not let me just jump to the page number at the bottom. That's just displaying for me what page it is, but it will not let me do that. But this should let me zoom on the side. So we will just use my other program to do it. And hopefully this will work better than the G Drive was working. And we will see what happens. Here's the whole other lawsuit that's attached. Literally everything is attached. So if I can get to page 700, we can get into the rest of the exhibits that I wanted to show you. Again, the largest I think we've dealt with that we've pulled up on screen at once was like one of those 300-page stupid Brown filings in the Toddy KJ lawsuit that made my head want to explode. But this is quite a lot of exhibits, and it's a lot of court records and transcripts. As you see scrolling on the side, these are transcripts of the hearings and the other matters, which I think are all appropriate and important. This is what I wanted to get to, which are all appropriate and important to go over. It's just a lot of stuff. So here's Kavanaugh's DM, which I'm sure has come up in other places. And now I don't know how to hide this. I don't know if I can do it that way. Hide sidebar. We figured out something new. Ethan, I'm not sure why you have decided to take it upon yourself to take it upon yourself and your show to malign, attack, slander, and defame me. I do not know you. I also don't know why you are spending thousands of dollars to have thousands of dummy accounts post fake statements about me on my Instagram and tens of thousands to have fake app store reviews of Triller. I am so curious how why Kavanaugh believes that Ethan was spending tens of thousands of dollars to have fake app store reviews made of Triller. Like, I don't think Kavanaugh understands how fan bases work, but okay. While amusing and slightly annoying at best, I wonder if that's a statement against interest, because in the court filing, Kavanaugh's lawyers said that this cost hundreds of thousands of dollars of damage. When we go back to the other California case, the Triller California case, not the federal case. And in this DM, it says that it is annoying, amusing, and slightly annoying. I think it's a statement against interest because that doesn't say that you have cost us money. While amusing and slightly annoying at best, I would advise you to stop and mitigate your damage now. Your toy podcast seems fun and all, but this is real business with real consequences, and you are causing real damage. What? It's slightly annoying at best. Is it slightly annoying, or is it causing real damage? Which is it? Also, a podcast that gets millions of views is not really a toy podcast. I would like to see the views Kavanaugh gets on stuff. I'm curious. Clearly, you are a very unhappy and disturbed human to take it upon yourself to attack someone you don't know with false and misleading information, especially to spend tens of thousands of dollars on it, but it must stop. You have been warned, and I will not be threatened and maligned and stand by. Govern yourself accordingly. It's so, he's just talking directly down to you, isn't it? I am Ryan. Hello, I am Ryan Kavanaugh, and your toy podcast is annoying. So I am going to file 1,000,000 lawsuits against you. 1,000,000 lawsuits. And the memes. Bring on the memes. A lawsuit with memes is my favorite. There aren't very many of them. There were no lawsuits with memes when I was in law school. I tell you what, I want an entire semester of civil procedure based on this case. Like between this and Toddy Westbrook, you could teach an entire law school class just using YouTuber lawsuits, and it would be amazing. The notorious KAV. First Amendment for me and not for thee. Triller versus Klein 2021. At least they picked a good picture. I like the background. Accused Ponzi scheme by ex-partner. Accusation later retracted. Look, it's well done photoshopping. I mean, forged documents, lied under oath, sued by babysitter, Hollywood financier is arrested for DUI again. They're just headlines. It's again, this is the tweet when you think of Ryan Kavanaugh, what comes to mind? And all of the responses in case the court wants to go through Twitter. Video. This is the entire printout of the does Ryan Kavanaugh look like Harvey Weinstein website, an entire printout of the whole website. Ryan Kavanaugh, apologies to my friends and family who are getting harassed and threatened by Ethan Klein and his trolls. I have not seen a scintilla of evidence that indicates that Ethan Klein threatened anyone. If you see it, tell me. I'm not trying to be blind, just haven't seen it. I've seen him clown on Kavanaugh. I've not seen Ethan threaten family or friends of Ryan. I haven't seen Ethan threaten Ryan. I've seen him make fun of him. Not cool to threaten and involve family. Not sure what they think they are gaining, but sorry they are doing that. Instagram really needs to step in. My friends and family are being attacked by H3 podcast people purely for posting on my Instagram. Actual threats. This must stop. I don't know him, but I understand he is doing this to others as well. Today, his people have tried to hack my email, my wiki successfully, and my LinkedIn and others. He does not text well. This is from Ryan Kavanaugh official going after Ethan. We're going to downvote your business on Google because you are running a Ponzi scheme like Cav, you fucking bitch. Oh, BT Way. That's not good. Again, threats aren't okay. And you can go after that person for making criminal threats. But interesting that they both follow Mr. Beast and 4 others. Also, that's not Ethan making those statements. Official Insta, the amount of DMs I'm getting with information on what he has done to others is baffling. I'm considering throwing an Instagram $25,000 giveaway for most disturbing story someone can prove he has done. So far, the ones I've got are pretty disturbing, but you don't know if they're true. The H3 podcast inciting violence, hate, and threats. Me and almost anyone I know getting the same threats and hate at Instagram, at YouTube, at Twitter, at Reddit. Please act before this causes more harm. File complaint here with the FBI with a video of Trisha being Trisha. HBO Max and Honey, please, we implore you to consider the hate and vitriol you are promoting when sponsoring the H3 podcast. Interesting. I wonder if Ethan, I mean, it might be enough for Ethan to just take the W and take the lawyer's fees, but if any of his sponsors did drop, and I don't know if they did, then he could show them what a tortious interference with business relationships suit looks like, because when you interfere with people's sponsors, if you know they are their sponsors and you are actively trying to encourage their sponsors not to work with them, and their sponsor said, "This is the reason we dropped you," that can be a tortious interference lawsuit. Um, so that is that. With hashtag stop the hate, by the way, that was the hashtag he used. He used hashtag stop the hate. Continued from my last tweet, I and Proxima Media will be producing a documentary on how Wikipedia can be used as a weapon by people like the H3 podcast with almost no remedy. Hashtag the Wikipedia truth. Look for a formal announcement to come. My Wikipedia has been hacked and destroyed by the H3 podcast foot soldiers. How is Wikipedia hacked? And I don't understand. I don't even understand what he's talking about. I really don't. Now we have concrete evidence connecting Throst and the H3 podcast. I just. Okay. Let's have some fun and up the stakes. This will be good fun for H3 followers to guess what we do or don't have. 25,000 to the person who provides the identity along with the legal and viable proof of Throst, and Popkey 35 must be absolute. First person to provide gets paid. And then the other lawsuits are attached, and the other lawsuits are attached, and the other transcripts are attached, and that Trisha A, I know I am still talking. We're going to get to just a few questions, and we will do more questions on Tuesday. I knew this was going to be long. I am sorry for the tech issues that delayed me a little bit more on getting all of that up. It is so much stuff. It's so much stuff in that lawsuit. It's just. But it's fascinating. Oh, and we need to do COPO. We do need to do COPO. I need to pull that up. But I'm going to thank our super chats. Fack, Sack, and Slap. A visit to a really strange salon. I love it. Oh, where they just talk about lawsuits. How to say chutzpah in Italian is mamma mia. Yes, I love that chutzpah was in there. I love it. I love that we got a little bit of Yiddish into the letters. The letters between the lawyers were just, if those kind of letters make you want to barf, don't be a lawyer, because that's what a lot of lawyers spend their time doing. That is not what criminal law practice is like most of the time. It can't be, but civil litigation looks you're watching it play out in real time. This is what civil litigation looks like. It's expensive and it can get pissy. I appreciate that Ethan's lawyers are clever with it. I can see why they're frustrated and mad. I would be too. I think that there are definitely things. My hair is just like whatever. I think that there are definitely things in Triller's letters where they're like, you're calling Triller a Ponzi scheme. That's not what's happening. It's just directly misrepresenting stuff. And that would get really frustrating as opposing counsel. Question: where do the judges have time to read the motion and the other stuff that the lawyer sends in? Is it law clerks that review the stuff, or does it depend? It depends on the court. And a lot of times it is research attorneys or law clerks. I have been a research attorney for civil judges. I spent an inordinate amount of time reading civil lawsuits, and I would regularly work for 12 plus hours a day. Also, I was just out of law school. I'm sure if I had continued working as a research attorney, it gets faster. But yeah, like 12 plus hours a day, day in and day out, not just reading opinions, but writing tentative rulings for the judge, briefing the judge on what all the different things are. It was a lot, but judges do read their own stuff too when they need to. Once they have the facts, like judges who sit with anti-slaps, they know the standard, they need the facts, they know there's nothing new and novel. And if there is something new and novel, it'll be pointed out by their research attorney. So it's a great, great question. Let me pull up, I need to pull up another window so we can do COPO. My brain has stopped. It like hit 10 o'clock and my brain's like, "Err." Emily, you have things to do very early tomorrow. Oh, yes, we do. It's a Pinewood Derby Day tomorrow. So we've got things to do. Yeah, Fred left cat hair all over me and peaced out. And my cat hair everywhere. moved my mic all over the place. So let us do COPO. We are so close to 199. We are so close. Let me pull up my channel. We're going to go to the poll on Twitter and the poll on the channel for COPO in just 1 second. Julie Scott said, do the recent sanctions on Russian oligarchs impact Pitt's lawsuit regarding the vineyard? How do you share a business with someone who's sanctioned? I need to look because apparently there's a lawsuit from the vineyard or the other vineyard company, the people Angelina sold her company to, against Brad Pitt. And I don't know if they are on the sanction list. I will look, though. It's on my list of things to do for sure. I hear you, Fred. You're back. Fred's like, aren't we done yet, woman? Yes, we're almost done. We just have to do COPO, which means we need to roll it. It's time for COPO. It's time for COPO. It's been too long. All right. I should have gone ahead and shared the screen while I was doing that, but I was paying attention to Fred. Let's be perfectly honest. What were we doing? I was paying attention to Fred. All right. From the YouTubes it doesn't tell me how many votes there are. Oh, with 6,000 votes, it's Britney Bitch has won in a landslide. So what Britney song lyric or song title should be the title of her upcoming book? It's Britney Bitch. And then I think the subtitle of that is like the toxic story of me against the music or something. I think there's opportunity for a subtitle, but it's Britney Bitch has landed at 59%. And then on the Twitters, it's Britney Bitch is there at 54%. So according to the law nerds and the court of public opinion, the title of Britney Spears' book, if it is going to be based on a song or lyric, should be It's Britney Bitch. So there we go. There was lots of conversation about it. I love it. And I think there's room for a subtitle. I do. I think there's lots of room for a subtitle. Fred is like, I am done with this fuckery, woman. It is time. Have I been fed? I haven't been fed. I am very hungry. So that was a lot of fun. I meant to do it for Tuesday. I forgot to put it up because I probably distracted about something. So with that, I'm going to be recording a new episode of the I Have Thoughts podcast. If you would like to join our community over on Patreon, that is where that lives. We will be having a members only live stream next week, which will be a lot of fun. We've got lots to talk about. There will be a new podcast episode out on Wednesday. I will see you on Tuesday for Coffee and Cursey Words, other housekeeping. Maybe YouTube will like us again. And we will be closer in range to the 200,000, but that's okay. We talk about the matters that are important, and sometimes the YouTube doesn't find it as educational as I do, and that's perfectly all right. I appreciate all of you. Thank you for being here. It is time for me to go eat and get some sleep. And Fred is literally stretched out. The length of this massive cat is stretched out on my desk as long as he gets. Come here. Can we show the Lonards how long you are, Fred? Fred's like a boneless cat. He's so floppy, but he's like stretched as long as he can be on my desk. You are floppy. He's like, no, I'm going to stretch as long as I can be on your desk. He's so fun. So with that, it is time for us to go. Thank you all for being here. Thank you for being a Lonard. Take care of yourself. Have a great weekend. I will see you around the social medias a bit. And if you want to follow me there at the Emily D. Baker, it's all going to be in the outro anyway. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.